Good evening, chat. Hello. We have the Karen Reed trial. We have a motions and sanction hearing. It's primarily a motions hearing, motions in limine, various motions that are being addressed, but also ultimately the court making determinations on the issues of whether or not the defense lied. And remember, the issue is, did Alan Jackson and their team, and we'll go back through all this, did they have a lack of candor with the court when they didn't tell everybody, oh, by the way, after the trial was over, we got an invoice from ARCCA, the crash experts, and we went ahead and paid it. Now, I brought it up at the time. I think that they would have been better off disclosing right away, and it wouldn't have been an issue. But now they did it, and, what is the judge going to do? She could sanction them a lot of different ways. I know what already happened today, so I know you guys probably already know what happened. But there's a lot of things Judge Cannoni could do, and we're going to see those. We're also going to see how the court's handling a bunch of other issues that are popping up today. So we're going to get started on that right now. And if you guys are new, welcome. My name's Sean, also known as Potentially Criminal. I'm an attorney in the Cleveland area, at Cleveland, Ohio area, and we're gonna go through this hearing that happened today. It's only about 2.5 hours long, and we're gonna watch it at about 1.3 times. So we should get done pretty quick, but we are gonna get into this here. And we're going to get started. There's also been a flurry of motions that have gone on. And it's going to be, we're going to try to cover those this week and try to cover those tomorrow. It was hard to get a hold of them all, but they are out there. Shout out to Bob Mata from Defense Diaries. Helped me out getting those. Oh my God, there's a ton of them. And I know not everybody's covered everything. But we are going to look at what's going on and what's been filed. And like every day, if you guys are on Twitter, every day something new is getting filed, and it's just nonstop at this point. It's just nonstop. And it's probably going to keep going now. I know there's some updates. Karen Reed's habeas petition in federal court got denied. I know she's trying to appeal to the First Circuit, and is the First Circuit going to accept it? Probably not. This is going to go to trial, and this is something I'm not trying to doom here for you guys, but this is going to go to trial, and I think Karen Reed gets convicted this time around. That's probably what's going to happen here, especially if the defense goes back to it was all a frame job, because it was highly incompetent and very corrupt, but they did not present nearly enough evidence for this to be a frame job. And I honestly went into this with an open mind. Once I realized, wow, I had my whole issues with Turtle Boy, and I realized, wow, there's a there. We went through the whole trial, and there was nothing. I mean, yeah, I can draw the dots, but is it enough for it to make a juror want to convict? No, or acquit? No. Do I think they need to focus on the things that will really help them, that John O'Keefe does not have injuries that are indicative of a motor vehicle accident, and that somehow his elbow shattered a polycarbonate car window or tail light and didn't damage him at all? Yeah, those are things they can harp on. Can they harp on the fact that all these witnesses are sus and sketchy as absolute get out? Yes. But I get the feeling if they start off again when Karen Reed was framed, she's going to get convicted. Like, if they start going down that road, Karen Reed was framed with what we know now, she's going away. She's going away. I'm calling it now. That's another one, chat. You can mark it down. It's my lock. It's the pick of the week. So that's where we are. Michelle's been a member for 15 months. She says, thank you, by the way, for 15 months of support. You look nice today, Sean. It says, tell the missus I said hi. Michelle says hi. Michelle says hi. On YouTube, like one of the viewers, chat. She just, well, why are you, like, she's allowed to be nice. Do you want her to tell you to fuck off? Oh, okay. Well, it's like she's trying to say hi. When you cover the JFK files? Probably on Friday. Friday we're gonna do a twofer. Friday we are covering it's in Ohio. Where the first thing we're covering on Friday is because it's in Ohio and I want to cover it. It's Con Wars. There's these two cons here in Ohio. Ohio Con. And then there's the Sick Eye Guild The Sekai Guild. And these two basically are, one group broke off of the Ohio Con, and now they're in a lawsuit over stuff involving the convention. So it's pretty cool. It's pretty cool. It's kind of funny. I mean, for these people, it's not funny, but as somebody who had sent me all this information, who was there? Extremely Happy Simmer. It took a while to read into this one because there's a lot there, and I had to go back through and watch like YouTube videos to get caught up on the lore. And buddy, it's interesting. It's interesting. So we're gonna do that. I got my hairs cut recently. I say yes on Thursday. I got my hair cut. My hair did. Adam says con maxing. Yes. EDW Raptor for $5 says you look like crap today, Sean. Tell Clyde hello. Clyde, hello. EDW Raptor says hi. Clyde, yes. What? No. I don't see anything. Mustache. What? Okay. The white fuzzball on my mustache. Okay. I'm like, are you sure it's not the white hairs? Because they're everywhere now. Paralegal is hello. Bama losses. We got you, Sean, today. Guilty. The bitch is going to prison. I'm like, I'm just saying it's something there. Oh, Brewberry says, I thought this was about convicts suing each other. No. It's like conventions. So we're going to cover, I think it'll be fun. Clyde treats the crumb on your mustache. Jeremiah says, yes, I'm crude. It's called Midwest Hospitality. Yeah. So, yeah, it's Coke. All right, guys. So we're going to get started, though, in the meantime here. It is time to go. Well, yeah, I was muted because 2.0 was talking to me. All right, so we're going to get started, chat. We're going to get this going. It should be quick. There's a lot that happens, and I was told to pay attention because there's one point where a bunch of stuff about Karen comes into play, and everybody's like, like that really happened apparently. So I don't know what it is specifically, but I was told to listen for it. So we're gonna hit this up, chat. We're gonna hit this up. Let me see here. Why is it not working here? Hold on, chat. We got it here. We're gonna do the JFK files on Friday. Just because there's so many of them, I'm gonna see what happens. And I haven't had a chance to look through them. And guys, I'm waiting for it to be nothing happens o'clock. So, we're gonna find out. Lee Harvey Oswald, they found his porn stash. Okay. Ooh, wow. All right, chat. So we need here we go. All right, so we're gonna start here, and it is time. And we have closed captioning, which will be great. And we have playback. There we go. And look at this chat. We already moved through and we've moved ahead now. Look at this. Look at this. We've already burned like 10 minutes. That's how good I am with you guys. So here we go. There's the light of justice.
Giddy. All persons having any business before the Honorable Beverly Finelli, Justice of the Northwest Superior Court before the County of Norfolk. Join me in, give your attendance, you shall be heard. Take the Commonwealth of Massachusetts. Court is now open. You may proceed.
22-117, Commonwealth versus Karen Reed. Can a counsel identify themselves? Starting with the Commonwealth.
Good morning, Your Honor. Laura McLaughlin.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. I'm Alex
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of the
Good morning, Ms. Little.
Good
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Ms. Giannetti. All right, so we have a lot to cover, but what I'm going to start with is a decision on the Commonwealth's motion to exclude employees of ARCCA. So I think I told counsel before that I had reviewed. So first we had full hearing from counsel. I heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read that transcript. And I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the ARCCA witnesses. They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCCA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover,
which at that point, if it's not in your care, custody, or control, you have no obligation to it. If it's not in my care, custody, or control as a party, I'm not responsible for providing it.
Here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCCA witnesses as ordered by the court. So I find or conclude that that was a material misrepresentation and that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations. And before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here. So.
All right, chat. So what's happening here is she's telling Karen, your attorney's fucked up. Now, ultimately, like I said, guys, I think the biggest issue here is they should have been forward with what happened. They paid the experts. So the issue is the experts were hired by the FBI and the DOJ for the federal case. Those experts then testified at trial. And those are the crash daddies. Remember the two guys that all the women were just seat bottoms were getting all soaked over? They were the crash daddies. They were, all the women were gooning over them. Those guys were supposed to be, they were the federal government's expert witnesses. Federal government had paid for. After the trial had ended, and during the trial, it was brought up who's paying for them, and they said, we're not paying for them. After the trial ended, ARCCA, the ARCCA guys, the crash daddy, sent Alan Jackson and the defense team an invoice for like, hey, it was 25 G's for us to be there, pay up. Well, it's from what I could tell, apparently the federal government's like, we ain't fucking paying for this. That's on you. So Alan Jackson's all right, fine. They scratch out a check and pay it. At that point, they had already said, no, we're not paying for him. Yet now they are. You have a duty to correct when things change and when material facts change. So at that point, there should have been a notice to the court saying, because remember, by the time July rolled around, And this check was cut. We knew we were going into trial number 2 already. So what happened there? So what happens? Well, they should have said, hey, judge, we just got submitted a bill. The feds aren't paying it. Apparently we have to pay it. So in all, candor to the court, we are going to pay it. This would have avoided the entire issue. And they didn't do that. Remember, you have to have candor before the court. You can't have a lack of condors before the court. Judges get mad when you don't have condors with you. So that's what happened here. Now, because of all this happening, Judge Cannoni wanted to speak with Karen Reed and say, listen, Karen, honey, your attorney's fucked up here. We have concerns that they were not candid with the court. They committed they basically lied. And that could be detrimental. Do you still want them to be your attorney? Do you want them to go along with this? And Karen has to be counseled on that privately by the court saying, are you okay with them doing this? And Karen's going to say, I mean, obviously she's going to be like, yeah, I want to keep my attorneys. And she's like, fine, then I'm not kicking them off the case. So, access with the candor of the court against the prosecutor. I don't disagree. Robert's saying, what did they lie about? They initially said they weren't paying for it. And then later on, they had to pay for it. So at that point, it's an omission. They're omitting things that subsequently happened. You have a duty as attorneys to correct the record if you learn about things later on and the case is still pending like that. And I agree the prosecutors lied. They've done a lot worse things. But you can't catch yourself up in these traps because a prosecutor's always going to get more leeway than you will as a defense attorney. They knew better. Alan Jackson knew better, and he should have done it. You should always disclose, like stuff like that, disclose it. So, yeah, and then also later on, they said they were never paid. And that's where it became the issue. Then he said, oh, well, we didn't pay him. And then remember, they had to have that hearing where Alan Jackson and them are like, humming. Oh, I don't know who. Nobody knows who paid the check, but someone paid the check. It's like, okay. So you see, that's the problem. That's the problem here. That's the issue. They got caught. And was it an intentional thing? Probably not, but you have to be very on top of your shit. So that's the issue. Justice was impacted by this. It's not justice. It's the rules of professional responsibility. As an attorney, I have a duty of candor. I can't lie to the court. And if I tell the court something is like, this is true, this is a true and honest fact. And then later on I learn, okay, it's not true and honest anymore. And we're still in the middle of shit. I have to go back and say, hey, judge, it's actually not correct anymore. We need to, for the record, it needs to be corrected. This is an own goal. This was an unforced error. They didn't have to do this. Now, this isn't a bombshell and the walls aren't closing in. But sanction them and get on with it. Well, Judge Bev is kind of doing this and run up the score a little bit here. She wants to do this for some style points. Let's be real. Let's be real about what she's doing here. So, yeah. So, it was entirely unforced. And here's the thing, guys. The cops can be scumbags. Everybody else can be destroying evidence, stuff like that. You have to still play by the rules. And this isn't even one of those times where stretching the rules would help at all. This didn't help Karen Reed at all, so I don't understand why they did it. So, that's the issue there. Why doesn't the defense buy cats to pacify the judge? Because that'd be bribery. You can't do that. You can't do that. All right, so let's keep going here, chat. We're going to keep moving. And Judge Cannoni just insulated the case from appeal issues because if Karen gets convicted, she's going to be like, oh my God, my attorneys fucked me. And Judge Cannoni's going to say, no, you said you're cool with them. So that's part of that is protecting the record. So,
defense and confront witnesses and the right to counsel, which includes counsel of her choice. So I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Ms. Giannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a manner, Your Honor.
Okay, so because Mr. Yannetti is not pro hoc vice counsel, and Mr. Yannetti can try this case if need be by himself. All right. But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So based on that, I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word, and I need to be able to take counsel at their word. So I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time. So, Commonwealth, I am denying your motion to exclude the ARCCA witnesses. Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan, and I will review any proposed curative instructions, limiting instructions, or final jury instructions. So that's my ruling on that. So we'll move on to.
So there you go. They didn't get fined. Nothing happened there. The little bit that's her grandstanding and being a judge. Remember, guys, I've said it before. When you're a judge, you're a bit of a prima donna. That's just kind of how it goes. But I think she wanted to take them down a peg. But yes, this is critical, though. When you're up there making objections in the heat of battle, like in the trial chat, every little bit of consideration you might get as an attorney, you have to protect, and you have to max it. You have to max. You have to, like, crumb maxing every crumb of favor you can curry with these judges. You have to keep. Think about it like when you're in, those of you who have been in, if you've taken classes like in college or things like that. If you show up to class, and you sign in all the time, and you participate, what do the professors say? That's not, that I won't factor that into your grade. There's no mandatory participation. But if you're on like an 88 or an 89 and I want to push you up into the next category, I want to push you up to the next letter grade, that a little extra bit gets you over the line. And if the judge trusts you and believes you, when you make an objection, and it's going to be something that's right on the line, it's going to be right there, right on the edge, chat, she might say, no, I'm going to go with them, not you. That's the problem here. That's the problem that they've created now. If she's going to give him the benefit of the, she might not give him the benefit of the doubt now. And now you're kind of in trouble. You have to be very careful about it. You have to be very careful. Yes, it's always harder on the defense, that too. And Alan Jackson would know that. And he would know that. So they already know that, like, they knew better. And this isn't their first time around the block. They're not a couple like first, second, third year attorneys. Alan Jackson's, he's got his time in the trenches. He spent a while as an assistant prosecutor. He worked with Emily Baker. Emily Baker and Alan Jackson, like, they're colleagues. Like, I don't know if they're like BFFs, but like they know each other. They work together. And Alan Jackson's done all kinds of, this isn't his first rodeo. So they all knew better. That's the biggest thing here. That's the thing that's going to hurt him. And God forbid there's a situation that arises where the judge is going to have to, like, it's going to be an iffy. Is it a ball? Is it a strike? And, if the umpire fucking hates you or thinks you're a piece of shit, guess what she's going to do? Going to call strike. So, yeah, he tried the Phil Spector trial as the prosecutor. Yeah. Yeah, she'll sustain every Commonwealth objection. She's not going to be that bad. She's not going to be that bad. But, you're not helping yourself. You're not helping yourself because remember, this is sales, but you're selling yourself to everybody. If the jury thinks you're an asshole, you're fucked. If the judge thinks you're an asshole, nobody's going to like you either. I mean, that doesn't help your client. That's not a good thing. So you have to be very careful about what you're doing here. And they didn't do that. They weren't very careful at all. But let's keep going. Let's keep going. So.
Mr. Leslie, you didn't have a chance last time on the motion to exclude the testimony of Dr. Wolf. So I'll hear you on that.
Thank you, Your Honor.
So this is now we're talking about there was a motion to exclude the testimony of Dr. Wolf. Remember, there was Dr. Wolf, then there's Dr. Schnetter, whatever, the Crash Daddies. That's one of them, Dr. Wolf. Dr. Rentschler, that's his name, Rentschler.
May it please the court. The proposed testimony supported by the Commonwealth of Dr. Wolf should be stricken in its entirety. The subject matter of Dr. Wolf's purported testimony by his own report and the Commonwealth's own motion is that Dr. Wolf will testify, is proposed to testify as to the cause and the manner of death of the decedent.
This is the different Dr. Wolf. I'm sorry. Yes, you're right, Luke. This is the different. I forgot there's more than one Dr. Wolf here.
That is the subject matter of the testimony. And as the court is well aware, in order for Dr. Wolf to be able to make testimony with regard to that subject matter, he has to demonstrate, and the Commonwealth has the burden of proof by a preponderance of the evidence, to demonstrate that he's qualified, prong one, and two, that the methodology is reliable, and specifically either that the methodology is commonly accepted in the relevant medical community, or that the proposed testimony can satisfy the 5 non-exhaustive factors of Dalbert-Lanigan. The entire motion, papers, and supporting documentation fail to even allege that the methodology is generally accepted in the scientific community. It's not alleged, let alone demonstrated. In terms of his qualifications, it is essentially Hornbook law that to testify about the manner of...
In chat, Hornbooks are what you use in law school. That's one of the ways to study. It's kind of like Spark Notes or Cliff Notes. Hornbooks are a little more in depth than that, but it's meant to condense and distill things down for you to study and learn through in law school. That's what a Hornbook is.
Death, as opposed to causation, this cause of death. You need to be a medical examiner, a forensic pathologist, or both. Conceitedly, Dr. Wolf is not a forensic pathologist and he's not a medical examiner. So I'm going to just put aside for the moment the cause of death. I want to speak specific because he's got to be able to show both because he's opining about both. So there is no demonstration in the record that is before Your Honor as to how Dr. Wolf is qualified to talk about the manner of death. Dr. Wolf invokes a terminology called mechanism of injury. That's the closest he comes to talking about manner of death. And specifically in his report, which is Exhibit A to our motion, the entirety of his opinion is in that exhibit, NDA 02801. It is a mere 15 lines, 1 paragraph. And the applicable aspects of that paragraph is he says the following. Based on the findings of his autopsy, his being the decedent's, it is clear that the mechanism of injury was a fall backwards, resulting in not only the basilar or skull fracture, but also a subarachnoid hemorrhage and contusions consistent with a coupe contra coupe mechanism. Mechanism of injury is not at all probative or even relative to cause of death. We're not talking about an injury here. We're talking about the manner of death. And mechanism of injury doesn't satisfy it. But the point first, Your Honor, is he's not qualified because he is a neurologist. His CV makes it very clear he's a neurologist, and his focus of his practice, by his own words, is based upon the precise invocation of radiation to treat incurable cancer. That's what his specialty is. That's what he currently does. So in terms of qualifications to talk about manner of death, he doesn't state the manner word, but he uses mechanism. He doesn't state mechanism of death. He states mechanism of injury, and mechanism of injury is irrelevant. So on qualification prong, Your Honor, it is completely lacking in the record that he is qualified. It's not enough to say you're a neurologist and head of neurology at a certain center. And this is juxtaposed next to the fact that the Commonwealth, the autopsy, which is very clear that those that are qualified, Dr. Stonebridge and Dr. Scorti-Bello. Dr. Stonebridge didn't even venture into the manner of death at all, didn't comment on it. Dr. Scorti-Bello, who is a medical examiner and who is board certified in pathology, she concluded that the manner of death was undetermined. So here you have the juxtaposition of a medical examiner qualified to render opinions in those areas, saying the cause of death is undetermined, and you have an unqualified neurologist not speaking to manner, but speaking to mechanism of injury. So in terms of the paragraph that I was just citing in his findings, it says, based on the findings of his autopsy, it is clear that the mechanism of injury was a fall backwards, resulting not only, et cetera, et cetera. And then he goes on to say the head injury was clearly inconsistent with any type of mechanism of injury, such as a bat, hammer, or a car hitting him directly. Then what he goes on to further to go beyond his qualifications, he says the frozen ground was enough that when Mr. O'Keefe fell backwards, his injuries were sustained. Where is the support that Mr. O'Keefe fell backwards? A neurologist can't determine that is a manner of death. He provides zero bases, zero, for his conclusion that Mr. O'Keefe fell backwards. Where is that? And it's also not in the autopsy. And with regard to his qualifications to determine whether the ground was frozen, I covered that with regard to Mr. Gilman. You need to be a pedologist. You need to know something about soil. He doesn't even begin to state how he concluded the ground was frozen. He wasn't there on the date of the incident. So there's no basis for that, but that is part of his opinion and methodology. And now to leaving his lack of qualifications, where is the citation to any study, any acceptance of how Dr. Wolf has come to his conclusions? There's nothing there. And this, Your Honor, is become a pattern of the Commonwealth where they put forth witnesses and they don't tether the methodology, if you can discern it, to common acceptance or the Dalbert-Lanigan factors. So in terms of both prongs, Dr. Wolf fails because the Commonwealth has not even begun to meet its burden. I would like to also reference what we just received last night, which is an article that was co-authored by Dr. Wolf. And I want to note and this is fractures of the classification and clinical features. This is 35 years old, and it is notable both for what it doesn't say and what it does say. First, what this article doesn't do is it doesn't talk about how one determines what a mechanism of injury is. So I'm even going to assume for the moment the parlance of Dr. Wolf, mechanism of injury. And if Your Honor would look at, please, page 593 of the study. And it's basically a meta-study. They went back and looked at a lot of data and information. But it says under results, second paragraph, the mechanisms of injury were similar for all three fracture types. Motor vehicle and motorcycle accidents were the most common mechanisms, accounting for 47%. And then it goes on and it says 3 patients were victims of falls. But what this article stands for is that those were all known mechanisms of injury. It was determined before this study even occurred what the mechanism was. This study is not how does one determine when it's unknown what the mechanism of injury is with regard to a decedent. And that feeds back into the lack of qualifications of Dr. Wolf, because we're not given one example of where Dr. Wolf, before his report, his one paragraph report, on conclusions of when he's ever done this before. It's not stated that he's ever taken a decedent and determined the manner of death. And I note that this study talks about mechanisms of injury, which scientifically is completely different from manner of death. And what it appears the Commonwealth is trying to do is to back into manner of death through the parlance of mechanism of injury. And that is not at all probative of manner of death. And lastly, this study only stands for the proposition of mechanism of injury. What they looked at is once the injury occurred, what were the mechanisms that were occurring through the brain? What happened inside of the brain that led to the various injuries? So this study doesn't at all, one, support any methodology. Number one, it doesn't stand at all that this is the methodology for how one determines in a decedent what was the cause, because the cause of the injury was already determined going into the study. And it also doesn't state anything about the paragraph that Dr. Wolf has explicated in his report. And I will conclude with 2 points. Dr. Wolf says, based on the findings of his autopsy, it is clear. Well, the autopsy doesn't come to any conclusion on manner of death. The autopsy doesn't speak to mechanism of injury. So it is a non sequitur, Your Honor, to say that based on the findings of his autopsy. And we know from Delbert Lanigan, you've got to apply your methodology to the facts and evidence in the case. And the only facts and evidence that Dr. Wolf uses, by his own words, is the autopsy, which doesn't support at all what he is stating in his report. The second and last point, Your Honor, is that it is not sufficient in the case law in Massachusetts. It's not sufficient under 702 for someone simply to come in and say, I'm a neurologist, I therefore know the brain, and then take the leap from that foundation into a conclusion with regard to manner of death. So in sum, Your Honor, he's not a medical examiner. He's not a forensic pathologist. He has not stated any experience whatsoever in doing what he's doing here, meaning to determine the manner of death of a decedent. And his methodology is completely unsupported. We only have one article, and I've gone through why that article is insufficient. So we would request, Your Honor, and urge the court to exclude Dr. Wolf from testifying in matters beyond his kin. And in the alternative, we would request an evidentiary hearing, because we and the defendant has a constitutional right to cross-examination. And this is the same with Mr. Gilman. It's the same with other experts where there is no statement of the methodology, as here, there's none, and there's no tethering to a study. And how is it that one can cross-examine a witness that doesn't even begin to approach the two prongs of the Daubert inquiry?
All right. Thank you. Mr. Brennan?
Very good arguments, chat. Very good arguments.
May I?
Please.
Attorney Lessie mistakenly misstates Dr. Wolf's credentials. Dr. Wolf is not a neurologist. He's a neurosurgeon. He's not simply a neurosurgeon, and it's not that he's a renowned neurosurgeon, but he has over 35 years of experience as a neurosurgeon. In addition to his opinion, you can see that Dr. Wolf has an extraordinary history of experience as a neurosurgeon. His CV is attached. In his internships as a neurosurgeon, he engages in an internship in pathology, neuropathology. We can see from his major research interests includes treatment of head injury, spinal cord injury. Dr. Wolf was the leader and director of the Miami Neuroscience Center for 17 years, from 1993 to 2011, the busiest neuroscience center in the country. He has treated tens and thousands of patients with head injuries, surgeries. His professional memberships are too long to list. Page 3 of his resume. His research is broad and precise and specific to head injuries. We can see in his research listed on page 4, he's principal investigator in dam treatment of brain tissue. acidosis in severely injured patients, principal investigator, PEG, SOD, and severe head injury. Improving outcomes in severe head injury, PEG, SOD, also principal investigator, IRB protocol, brain pathology. He is well published. His book chapters that he listed anyways, list 16, many of them dealing specifically with head injury and brain injury. Book chapters include head injury and difficult medical management, pediatric neurosurgical emergencies, complication of head injuries in adults, imaging of cranioscerebral trauma, imaging and trauma and critical care, emergency room assessment of head injury patients, intracranial injuries. He has numerous journal articles, a slew of them specific to head injuries, intracranial pressure.
Here's the thing. Like, I don't think anybody's claiming that John Cook didn't smack his head on the ground. He did. But why did he smack his head on the ground? And yes, there you go, chat. There's Turtle Boy, like, center stage. The issue is there's nothing Kieran Reed did that would demonstrate, like, if he got hit by the car, that would not leave any of the cranial injuries he suffered. That's from cracking your head on the ground, which nobody's denying happened. And I'm sure he cracked his head on the ground and passed out. So I don't understand why the state really feels the need to have the medical expert. Like, I think if they had just stipulated to it, but yes, before, I think when we were at trial the last time, Lally tried to say this was evidence that Kieran Reed caused these injuries. And that was a big issue, I think, if I remember right.
200 journal articles. Initial management of brain and spinal cord injuries, number 9. Number 16, which is the document that I produced to counsel last night, listed in his journal articles, number 16. Fractures of the clivus, classifications and clinical features. His journal articles are numerous, too numerous to go through, but you can see that he is well published, over 70 articles. His presentations, specifically on fractures, basal type injuries, number.
It's not really a misdirection as a bold strategy. It's just like, I don't think, like, they're going to say Kieran Reed, you know, and John O'Keefe cracked his head. Like, I think everybody agrees. And Luke, you're saying, I don't think they're open to him getting smacked with a weight or something. Fine. But it's also consistent with slipping and cracking your head on the ground. And Luke, this is the biggest problem, though. If they go down that road of this is some sort of elaborate setup and John got beat to death in the house, they don't have like, we might think that there's not enough evidence to carry the day. They're getting boned trying this. Just accept the fact, yes, his injuries are conclusive of blows to the back of the head. Well, Karen didn't he didn't get hit in the back of the head with the car. So therefore, how did he get these injuries? And that's where they should go. If I'm the defense, that's where I would go with this. Breeze says, can they explain the arm injuries? No, they can't. They weren't able to last time. They were not able to last time. So Augusto's saying you got to try to say Kieran didn't cause him to fall. Well, the biggest thing is you don't have to. John Cook's dead. John Cook died from hypothermia because he was laid out in the snow. How did John Cook end up in the snow? That's the point that the state... John O'Keefe ended in the snow. How did John O'Keefe end up in the snow? There's no answer to that. Like, John O'Keefe is laying in the snow, right? John O'Keefe, sorry, guys. John O'Keefe's laying in the snow, passed out, and he's getting hypothermia, and by the time they take him to the hospital, he's dead, right? How did he get there? The state doesn't have an answer for that. Remember, they don't have motive, but they've got to show how he's there. What put John O'Keefe there? They don't have the answer for that. And if I am the defense, you need to keep pointing that fact out. John O'Keefe died. Okay. He was found in the snow. Okay. How did he get there? There's nothing there. We don't know how they get there. You go to I don't know, but the I don't know includes a shady fucker's house. Fine, but you can't do that. Like, you've got to just say the state can't prove it. Hang your hat on the Alberts and the McCabe's. They tried that the first time around. They don't have enough evidence for that. So I would never do it if I were them. I would never do that. Now we know the jury's not going to buy it. Just focus on the fact of John O'Keefe's laying on the ground dead. You can't tell us how he got there. And that's reasonable doubt. And that's what they should be focusing on. That's what they should be focusing on. If I were them, that's how I'd focus on it. Jim says, what if they're wrong and John O'Keefe just slipped on the ice and busted his head? Very likely. That's very probable too. I'm just saying, at that point, you just focus on the fact it could be anything that did it. And that's what the more effective means is saying. It could be a million different things that caused it. You can attack the credibility of these witnesses, but when you start off with she was framed, you better fucking prove the frame job, and they can't prove the frame job. So they shouldn't be talking about a frame job. Just say there's no explanation to what happened to John O'Keefe that makes any sense to you at all. That's what they need to focus on. That's how they should do it. But I agree, Jim. It could be any number of things, but they're not going to win by doing this. Yeah, Jen McCabe looks suspicious as hell. Yeah, and there's guys, and here's the thing. You could point out the pig DNA, all these things that don't add up. Great, do it. The dog disappearing, everybody having a phone, that they all took their phones and broke them in half and threw them away. Yes, they're all liars and scumbags. There is not enough evidence to prove they killed John O'Keefe. There is not enough evidence to prove that. You should talk about what, and Bella's right here. You talk about why the investigation's sketchy and it's faulty and all these witnesses suck and they don't have credibility. Leave it at that. And then you tie it into the fact that nobody, even the doctors, can't explain why and how John O'Keefe got there and like what happened to him. They can't explain it, and that's where you need to stop. So, that's where I think they go. Yeah, this is another plausible explanation. But you need to throw these out there. But when you start off saying Karen Reed was framed, it's like, well, no, she wasn't framed. The police were just incompetent. And that's the problem here. That's the problem here. And if they don't go down if they don't do this the right way, she's going to get convicted. So that's all I'm trying to tell you guys.
5 on page 13. Number 9, neurosurgical management of traumatic brain injury. Number 10, acute head injury. And the list goes on. Over 90 references. Lectures and meetings, many of them dealing with head injuries. Over 100 lectures listed for reference, actually over 130, and a number of web publications. So this neurosurgeon, who has this extraordinary experience, is qualified. The ability to testify about head injuries and medical diagnosis and cause of death is not limited to a pathologist. In fact, I would suggest that the experience of Dr. Wolf is far superior to any pathologist. The difference is a pathologist treats patients that are already dead. Dr. Wolf treats patients that are in trauma, who some survive and many die. So he is intimately familiar, not just with looking at a deceased in a lab. He's intimately familiar with assessing the injuries after they occur, diagnosing what the injury is, and an attempt to save the person's life. And so he's well attuned after tens of thousands of surgeries to understand the causation of a brain injury and what causes death. Looking at Dr. Wolf's report, although short, it is clear that the injury that was occurred by Mr. O'Keefe was an injury known as counter-coup. And I dare say the defense proposed expert, Dr. LaPosada, is not in disagreement with that. To understand counter-coup, it occurs from a fall backwards on the ground. It can't occur from a bat or a punch or hit. There's not enough force. It occurs when the back of the head hits the ground, and then the brain shifts to the front of the head. That is what the autopsy reports show. It may be that the medical examiner for the Commonwealth didn't have the same level of experience and didn't diagnose it, but this expert does have that expertise, and it is no different than the pathologist that's proffered by the defense. The periorbital ecchymosis that is directly related to the basal fracture, the swelling around the eyes, no different than Dr. Lopasada's opinion, exactly the same. One thing he doesn't say is that the body was moved. There was no evidence or information for that. He doesn't extend himself as a detective or put in unplausible theories in his proposed testimony. He is intimately familiar with counter-coup, having treated tens of thousands of patients, and he understands in counter-coup how it can lead to suffocation at the top of the spinal cord. And so his opinion is clearly supported by his extraordinary experience, his writings, his history. It can't be that his ultimate conclusions of counter-coup and ecchymosis, periorbital ecchymosis, is in dispute. It seems that the defense simply prefers the original medical examiner for the Commonwealth. But we expect to call Dr. Wolf, and I would suggest that he's more than qualified.
All right, thank you. Mr. Ellis, anything final?
Yes, thank you, Your Honor. Mr. President. Thank you.
Your Honor, I'm going to note what Attorney Brennan did not state. He did not address at all how the methodology, to the extent it's discernible of Dr. Wolf, is commonly accepted or it satisfies any of the Daubert factors. And that is the fatal aspect of Dr. Wolf's opinion. It's not stated. You have to have either common acceptance or satisfaction of the 5 non-exhaustive Daubert factors. It wasn't addressed, and I think it's reasonable to conclude that it wasn't addressed because it doesn't exist. That alone dooms Dr. Wolf's opinions. I will stipulate, for purposes of this argument only, the cause of death prong. Let's assume, just for purposes, just to focus on manner of death, let's assume hypothetically that Dr. Wolf is qualified to testify about cause of death. Mr. Brennan did not address at all his qualifications to discuss and opine on manner of death. And that is the distinction I emphasize, Your Honor. Manner of death, he has not stated one qualification on manner of death. So the defense urges the court to draw the distinction, to limit his testimony to cause of death, not manner of death, because we know, and we cited the Graham article, which is attached to our motion, which specifies who is qualified to talk about manner of death. Because what does manner of death do? It takes into account all the circumstances surrounding it, the crime investigation. That's what medical examiners and forensic pathologists are qualified to do. Attorney Brennan cited that in his CV, there's a reference to an internship in pathology. I looked, I didn't see it, but let's assume that it exists. Let's assume he has an internship in pathology. That does not qualify him to engage in manner of death 40 years later without any experience from that internship all the way until 2025. Lastly, Attorney Brennan goes through numerous studies, and I appreciate that he did because the CV is almost endless with meetings, presentations. There's 4 peer-reviewed articles. That's it. 4 peer-reviewed of Dr. Wolf. None of them address or come close to the topic that he's talking about. My last point is this with regard to Dr. Wolf's qualifications and what his practice has been. And Attorney Brennan concedes it by his own words. He said cause of injury. And again, for purposes of this argument only, I will concede cause of injury. But manner of death was not addressed by Attorney Brennan. It's not addressed in any of the qualifications of Dr. Wolf, and it's not addressed in terms of the one paragraph that we have. And for something as significant as this, one paragraph that doesn't address common acceptance, methodology, Daubert factors, Your Honor, I don't know how a record is even begun to be established for him to be qualified or to opine on manner of death. So we would urge Your Honor to find that he is not qualified to testify about manner of death, that mechanism of injury cannot be manner of death, and that he be so limited to the extent the court desires and concludes that he has some relevance here. But in terms of all of the record that's presented, including the CV, etc., there's not one instance where we see that Dr. Wolf has even approached determining cause of death or manner of death at all. So I don't see where there's a record to find him being able to do that for the first time in charges of this nature. Thank you.
Okay. Do you want to respond at all, Mr. Brennan?
At some point, arguments become semantical and theoretical, but not practical.
The law is about semantics. The law is about arguing over what does a word mean, Mr. Prosecutor. So yes, it's all about semantics. That's what we do. We argue about what does this word mean? What does it mean in this situation? How about here? How about there? That's what we do. That's what we do. Just it's so ridiculous here.
This doctor has treated thousands and thousands of patients, many, unfortunately, which have died. And as a neurosurgeon,
Doesn't sound like a good doctor.
engaging in the operations and the study of the brain and the patients, it is obvious that the neurosurgeon would understand and appreciate why his patients are dying, because that is part of the study of trying to save them. So for him to reduce on a piece of paper that the manner of death is based on my thousands and thousands of patients and my years and decades of experience, seeing firsthand many of these patients I cared for or tried to help died, and this is why. Technically, he could do that if that satisfied Mr. Alisi, but that is so unnecessary because it's obvious.
Is it obvious?
Okay.
Is it obvious? Not to me.
All right. So we have a series of motions in limine. I'm going to start with defendant's motion to present the demonstrative exhibit on Christina Hanley's testimony. It's paper 558. Is there an objection from the Commonwealth on this?
There is an objection.
All right. So I'll hear the defense on this motion.
Thank you, Your Honor, if I may. This is a relatively straightforward and relatively short.
I have a question. Did you use this last time? It looks like
We attempted to use it. We had it last time. It was shown to the witness, but it was not allowed to be introduced. And all we're asking is for that next step, that it be introduced into evidence.
did she adopt it? Was there okay?
She did indicate, and that's part of my argument, Your Honor, which is
So I'll go ahead. I'll hear you.
I'll truncate it. It's a relatively simple request. We just want to use the chalk that was prepared in the first trial. No dissimilarity there. It was disallowed for use by the defense to be actually used, to be admitted, but it was shown to the witness. It was not shown to the jurors. The evidence, as the court will recall.
So let me just have, so you're just trying to use it as a chalk, not an exhibit.
No, we would ask that it be used as a chalk and an exhibit that's introduced. I'll take the chalk if the court wants to break it into two different pillars, but we believe that once the witness, and I anticipate based on her prior testimony that she would adopt it one more time for its authenticity or its accuracy, I should say, that it be used as an actual exhibit that goes back with the jury just for their help. The court will remember it's very complicated.
So let me just, with that, if I allow it as a chalk, is there an objection from the Commonwealth?
Would be a partial objection to a chalk, some of the labeling. I have less concern of a chalk as I do an exhibit.
And so we can take it in two steps. I certainly don't need to decide now whether it's admissible, and I couldn't. But what's the nature? Is this something?
The court will call this. This deals with glass. Christina Hanley spoke at length about her analysis of pieces of glass, other materials as well, but specifically as it relates to the glass. There were more than a dozen pieces of glass that she testified to. They were variously found in different places at different times by different people, and they're assigned a relatively complicated set of numbers that she utilized in her analysis.
And this is what you explained to me was the 47 pieces of glass that I asked you about last time,
No,
right?
this is more attended to the glass in the bumper.
Okay.
The glass in the bumper, the glass that was found at 34 Fairview, as opposed to the lens material that were the 47 pieces.
Okay.
These were a bunch of pieces of glass that were that originated from multiple sources. Some matched each other, some did not match anything else. Some were from the same source, some were from multiple sources and different and distinct between and among each other. We reduced the very complex. The court may remember she talked about 7.14-B matched or didn't match 7.13-C, and it was very numerical and very difficult. It was difficult for me to follow. It was even difficult for the witness to follow because she continually had to resort to her own report as she tried to maintain her accuracy. So
Do you have the day of her testimony?
Gosh.
Ms. Little, do you have that transcript pulled up?
Yes, one moment.
So obviously, I remember her testifying. I remember seeing this previously.
Okay. June 5th, 2024, Your Honor.
Thank you very much.
Thank you, Ms. Little. The court will recall, and I think it's clocking with the court's memory, that we did use the demonstrative aid. We walked up to Ms. Hanley. We showed it to her on the witness stand, and she did adopt it. And she indicated that once she studied it, it was in line exactly with her testimony. It's an accurate visual representation of that evidence, and it just makes it a lot easier for the jurors to find some sort of linear logic to the evidence, what matched what and what didn't. And all we're asking is that we'll use the same aid, the exact same aid that we did last time, and just ask that it be used as not only a chalk. As Mr. Brennan said, he may have a slight objection to that, but also we would ask for the next step, which the court doesn't have to decide now. I think waiting on Ms. Hanley's testimony would be apropos, and then we'll ask for its submission at the right time.
All right. What's the objection, Mr. Brennan?
This witness has a report, and a report is not admissible and can't be shown to the jury. And so to have the defense summarize her testimony when she's not allowed to put her report in herself seems a bit imbalanced. There are references on this potential chalk that lists troopers' names. Those names shouldn't be on there. But also, it doesn't give the full picture of the actual testimony. The issue regarding glass, I expect, is going to be a issue in the next case. And I say that because we learned last night, for the first time on a public airing of an episode, that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car. Now, that is the first time we've had any statements from Ms. Reed suggesting that. And also, there was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face. Never heard that before. So we have this evolving or new testimony.
And this is apparently the thing I was told to be careful about, chat. I guess in the Karen Reed interviews, she, guys, I'm getting the chalk thing. I'm trying to sort that out. Give me a second. Listen to this. Apparently, Karen Reed in an interview or TV show talks about pulling glass away from John O'Keefe's face. It's like, this is why you don't talk to the press. This is why you don't give interviews. This is why you don't do that thing. This doesn't help. Why would she say that? I don't know. Now, could Hank Brennan be lying? I don't know. But this is really stupid of her. This is really dumb to go talk to the press. When does it start? Trial starts April 1st. Jury has not been selected yet. Jury selection starts April 1st. So, why would she do interviews? Because they're kind of retarded. Yeah, this was just dumb. Yeah. So I don't understand. And guys, this is just why you don't talk. This is why you do not talk. And yeah, apparently this is what Karen Reed says in the new documentary that came out, the new series, and she says he had a piece of glass perched on his nose, like wedged like a splinter. You're just like, why would you? Yeah, I just don't know. I don't know. I don't know why you would do that. I don't know why. I don't know why that would be in there. It just it confuses the hell out of me. I just get and guys, Christina Hanley, she's the forensic she tried to piece together all the broken taillight glass and the broken cocktail glass found near John O'Keefe. That's what she's talking about, putting it all back together. So that's what she was talking about. I don't know exactly what the whole chalk thing is, okay? So I don't know. I don't really recall the whole chalk thing. I don't really understand that, but whatever. So she did say it on the documentary last night? Oh, buddy. No. Oh, Jesus Christ, Karen. Oh, no, buddy. No. 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 Gosh, she really did say that. Yeah, this is not good. This is not good now. Oh, the chalk was a demonstrative. Oh, they used the chalk to show like how the chalk broke and, shattering like the light. Okay. Oh, when they talk about the chalk of just when she drew stuff. Oh, I forgot. She did draw things. I forgot. She did draw things out, and that's why they're calling it a chalk. Okay. You wouldn't call that here. You just call it an exhibit. You would call it a drawing. So that's why I was a little confused, but they're using old school terminology there. Wow. But yeah, if she really said that, who buddy? We're going to rewind that just a hair. So
testimony. The issue regarding glass, I expect, is going to be a issue in the next case. And I say that because we learned last night, for the first time on a public airing of an episode, that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car. Now, that is the first time we've had any statements from Ms. Reed suggesting that. And also, there was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face. Never heard that before. So we have this evolving or new testimony, or statements about glass. And so I think first, I'd like to consider this new information that we just learned last night. And secondly, I am reluctant to agree to a simple summary of part of the witness's testimony that has not only labels on it, but does not, from my perspective, clarify anything. I'm not opposed to chalks. I think chalks are helpful for both sides. And I think the liberal use of chalks is helpful. But I don't have confidence this chalk accurately summarizes the witness's testimony. I'm open to discussing chalks with the defense and perhaps learning why they think this is helpful and important, but looking at this chalk, it does not look clear to me. And I do think that the evolving nature of glass in this case is going to be an issue. And since I've just learned this information, I want to give it some thought.
Okay. All right. So, Mr. Jackson, what I'm going to do is just hold off and see where the evidence is, what the two of you talk about. Maybe there's some agreement you can come up with regarding this. I need to hear more of the evidence again.
I understand.
And I'm going to read the transcript, so that will help me with
I think
this.
it makes sense. Mr. Brennan indicates that the chalk was not helpful to him. With all due respect to Mr. Brennan, it's not really his understanding of the chalk that is going to sort of seize the day. It's Ms. Hanley. So I do think that if the court would keep an open mind,
Sure.
Ms. Hanley testifies, then that would be the appropriate sign.
So I'll take no action on this, and maybe it's something we can address the day before she testifies or something as it gets closer.
Sure.
But the two of you should talk.
Ghost, you're saying, why would the TV show be admissible? It's a statement Karen Reed made. It's a statement you made. It's a public statement. It's admissible. It's a statement of a party opponent. They might be able to, I don't know if they're going to use it or not, but that's why you don't make public statements, because they can be used against you.
Sure. I'm open to working with them if there's something they want to explain.
All right, great. Thank you. All right, so no action taken on paper 558. So one question, the next motion I have is defendant's motion to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. The Commonwealth has a sort of maybe a similar one that I'm not sure. The Commonwealth's motion eliminate to admit the victim's out-of-court statement relating to his state of mind. So the Commonwealth's Binns and Qualls motion, does that address the Aruba witnesses? I'm just wondering if they're hand in hand. So the paper number on the Commonwealth is 585. It's got your 11 on it, though. So the defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. It deals with the, let's just say, the Aruba witnesses. I don't, Marietta Sullivan, Laura Sullivan. Does this, Ms. Giannetti, I think this was one filed by you, maybe it wasn't. Does this include the children as well?
This does not. This is limited. This argument will be limited to the, we'll call it the Aruba incident.
Okay. All right. So given that might not include the Commonwealth's number 11, the Qualls, Binns, the defendant's statement, the victim's state of mind as it goes to the defendant's knowledge and ability, likelihood to act on that state of mind.
The defendant,
So I just want,
I didn't mean to interrupt, Mr. Brennan. Do you want to?
so I just want to know if that is part of the Aruba one.
Okay.
so our statement relating to Mr. O'Keefe's state of mind is broad. It would have included the Aruba, but I can make quick work of this. We
Okay.
do not intend to introduce evidence about the Aruba event.
Okay.
I reserve the right, if the defense opens the door, then we may proceed with it. But in our case in chief, we don't intend to introduce any evidence from the Aruba event.
Okay.
Short
There we go.
affirmative.
All right. All right. So, Mr. Brennan, you can have a seat again, and we'll go through the defendants on that.
Wow. Okay. See, so you guys remember the last time around, the whole Aruba thing was that like they went to Aruba and John O'Keefe was talking to like one of the women who was like a cousin, and allegedly Karen comes out screaming like he's talking to some hoe. And John's kids, the kids John O'Keefe had guardianship over, saw it, and everybody's like, oh my God, Karen's a bitch. And they were trying to show that like Karen's so fucking crazy, she'll go off unhinged and like run him over and all kinds of things. And it happened shortly before he died. I think it's interesting. They're not even going to go to that point. And here's what I will tell you. As much as I don't like Hank Brennan, he is going to be far more efficient than Lally was. Lally was bumbling and stumbling through his case. Brennan's going to have this streamlined, so it's actually probably going to seem a lot stronger overall.
Very helpful. So I will endorse it as Commonwealth does not intend to introduce in its case in chief. If that changes, Mr. Brennan, you need to come to sidebar well in advance, okay? After telling counsel.
Understood. Thank you.
All right. All right, so that was 5:59. The defendant's motion eliminate for review. Is the Commonwealth seeking a view as well?
We did not move for review, but we do not object if the defense wants a view.
Okay. So who's going to argue this for the defendant?
I'm Your Honor.
Okay, so what's different this time around is you're asking that Ms. Reed be permitted to attend.
Yes, Your Honor.
So I'll hear you.
It's about a jury view chat. You have the right, depending on the type of crime, sometimes you want to have a jury view, like where a murder took place. Or, for example, here in this situation, they're going to take him over to 34 Fairview Drive, and they're going to go see that area. I mentioned this before. When I was an assistant prosecutor, we had a chase that went through the county we were in. And there was a jury view. And the jury view was everybody hopped on the bus, and we went the route of the chase. And it was to give, and the prosecution asked for it, our office asked for it. It was meant to give the jury to understand, like, how far this chase actually was, and, like, put it in your mind how ridiculous this guy acted. Even though the chase was mainly at roadway speeds, the guy drove for, like, 15 miles, just doing whatever he wanted. So jury views can be critical, allowing the jury to understand what's there and show you what a picture doesn't show you. Now, is the defendant always on those? Not always, but here in Ohio, a defendant would have the right to be there. Counsel's there, the judge is there. So they're asking to go back over there again.
Your Honor, the defense is requesting that it exercise its broad discretionary powers to allow a view under Massachusetts General Law 234A.
So I'll allow a view.
Okay.
Okay, but let's talk about your client attending it.
Yes, Your Honor. There was a request in there for Ms. Reed to attend. That is something that's allowed under the law.
How do you propose that's done?
If it's possible to have separate arrangements for her to be there, vis-a-vis some other transportation so that they're not all on the same bus. If the court can make that accommodation, we would appreciate it. But the most important thing in this case, Your Honor, is that there be a view of both the vehicle and 34 Fairview Road.
All right, so the Commonwealth's not objecting to a view of the vehicle and 34 Fairview, correct?
I'm not, but I do not think the vehicle should be at 34 Fairview.
Okay, what are you proposing for that?
We could make arrangements and make suggestions, but it's not going to replicate the circumstances of that evening. And so it creates an image that is inaccurate. So I do not think that the vehicle should be sitting in front of that home in totally different lighting conditions, timing conditions. And I think it can be misleading.
All right, I need some suggestions. Why don't we table this for a bit, even if we do this one tomorrow? So one of the concerns I have about just logistically, people will have to stay away. When Ms. Reed's in court, there are a lot of people who come to court. So I need some assurances that there will be people kept at quite a distance. a separate car is fine. Would counsel plan on being in the car with her?
That would be fine, Your Honor.
So I need some proposal. So I need more information from both. So, Mr. Brennan, I'd like you to come up with a proposal about viewing the car a separate place or a separate time. It would be ideal if we could do it at the same time, but at a separate place. If that's what we decide, we may have to do it all at once.
I do think it's important, Your Honor, that the vehicle be at the scene just for dimension purposes so that the jury can get a sense of what it would have looked like at the scene. And I think just for convenience purposes, it saves a lot of coordination on the court's part and in terms of juror time by having it all happen in one fell swoop.
Okay. All right. So let's try and figure out some of the particulars. I would like to have Ms. Reed be able to attend, so let's figure out some particulars. All right. So defendant's motion eliminate to exclude certain witnesses before and after testimony. That's 462. And I think we can address the Commonwealth's motion for sequestration that moves to exempt family members at the same time. So who's arguing? 562. Did I say 4? Sorry.
Yes.
562 and 576. So Ms. Little?
Thank you, Your Honor. I'm handling the motion to exclude certain witnesses. The court has broad discretionary power to sequester witnesses before, after, and during their testimony under Massachusetts Rule of Criminal Procedure.
Hi, Sleuthie. How you doing?
The defense respectfully
doing
requested
well.
this court issue an order for sequestration in keeping with what the Commonwealth also requested. But additionally, excluding Brian Higgins and members of the Albert and McCabe families after they testify.
So do you mean after the evidence is closed?
I mean, after they've taken the stand.
So after they've taken the stand, but so witnesses are sequestered not to influence any testimony. So once the evidence is closed, just before closing arguments, are you saying they should not be permitted to come into the court for closing arguments?
Yes.
Focus on that part of your motion.
Yes, Your Honor. We're asking that they not be able to attend closing arguments, and this is why. As the court likely recalls, at the first trial, members of the Albert and McCabe families continued to attend court after their testimony. During closing arguments, Colin Albert, Ryan Albert, and Jennifer McCabe were all seated in the jury box with the O'Keefe family. At least one juror who was seated in this case indicated to a reporter at Vanity Fair that she felt intimidated by their presence at closing arguments. Your Honor, a sitting juror reporting feeling intimidated by the presence of third-party culprits towards the close of the case is highly concerning.
Was this a deliberating juror?
I don't know. He or she was anonymous.
Okay.
And Your Honor, that was by design. There is information that the Massachusetts State Police and the District Attorney's Office wanted to have the third-party culprits seated there during closing arguments. And so on that basis, the defense is requesting, in order to protect there from being any sort of undue influence or intimidation, or even just the potential that a juror might feel that way, as we know at least one did in this case, we're asking that they be sequestered after their testimony and during closing arguments.
What's your position on the Commonwealth's motion to exclude the family members of both the defendant and the victim?
I believe that the sequestration order, yes, we join in that request.
Okay.
The only exception I would note is that experts should be able to obviously watch other expert testimony that deals with their.
All right. So obviously is not something that should be in a motion. Okay. If you've got an agreement that each other's experts can.
Okay, actually, you do in this situation. You're dealing with, in this case, just going off of what's obviously supposed to happen. No. Belt and suspenders. I want the experts here. Because you know Hank Brennan's going to go, well, you never actually said that. That's what Hank Brennan's going to do. And Judge Bev will go, well, I guess that's right. I guess we can't do it. No. It's sorry, Judge Bev, you have not earned the credibility to be trusted to make obvious decisions. So no, I think they should say it. They should protect their ass here. Also, does the entire, Karen's parents look old, but does this entire O'Keefe family, do they not work at all? Are they all on welfare? How can they attend every freaking hearing and not lose their jobs? I don't know. I just don't know.
Be in the courtroom during the testimony, that's one thing, but it's not obvious that they're permitted. Okay.
I just wanted to make sure that would be excluded from the order that the Commonwealth proposed. Because the way that they wrote it, it says all witnesses. And I'm guessing that, I don't want to speak for Mr. Brennan, but I'm guessing that they will want their experts to watch our experts and vice versa.
All right. So you all need to talk. All right. And if there's a disagreement, you need to put it in writing. Generally, experts are permitted, but it's not a given. Okay. All right, Mr. Brennan, do you want to weigh in on people being able to, I'm concerned about after the evidence is closed.
I think it's unfortunate that not only a time-honored tradition, but an entitlement for a witness after the evidence is closed to come into the closing and watch the closing. The defense tries to take an opportunity to provide an unsolicited bashing on their targets. They name Higgins, Albert, they invoke those names, they characterize third-party culprit, and they suggest that some anonymous person was uncomfortable. It seems as though the presentation has a deliberate point.
It wasn't just an anonymous person. It was a freaking juror. I mean, this guy, he's so condescending when he talks. God, imagine if he was your dad and you're playing baseball. And he's like, well, son, you just didn't hit the ball right. Imagine this being your dad. Imagine this being your dad. I mean, God, he would probably put angry Asian father to shame.
Promote a cause, but it doesn't have any sense of balance or fairness whatsoever. Witnesses, all witnesses from either side should be able to come into a courtroom after the evidence is closed, the sequestration order has ended, and watch a closing. Grace can be offered in these circumstances sometimes, and that's what I've tried to do in my motion. Ms. Reed has 3 potential family members who are potential witnesses for the government, and certainly I would have a right to try to ask the court or insist that they should be sequestered, but I've specifically asked that they not be sequestered.
Because you don't
I think
care.
that an accused has a strong need to have family support in the courtroom. It's not in the benefit of the government or the Commonwealth.
Yes, it's like you're acknowledging, wait, defendants have extra important rights compared to everybody else in a trial setting. Yes, she has extra important rights. It's like they do, Hank. Yes, you're on the cusp. You're on the cusp of figuring it out.
But it's fair. It's just. It's graceful. And I think that Ms. Reed's family should sit through the court testimony, even if they're called as witnesses, as should Mr. O'Keefe's immediate family. The idea that witnesses should not come in after a evidence rests and during a closing, not only does it seem quite unfair, it doesn't seem to have any basis in law, in justness, in courtesy. And so I ask you to deny the idea that these targets of the
That's what we're
defense
talking
should not
about
be
now
able
is
to attend the
courtesy.
closing. But I do ask you to endorse my motion that would allow family members to have the benefit to sit through the court
Good
proceedings,
Lord.
even if they may or even if they do become witnesses.
Good Lord, on a surfboard.
Okay.
Your Honor, if I could address one issue.
Sure.
There is some additional information. I was hoping we might be able to address sidebar because it is subject to a protective order, but I would like to make a record.
He's like, well, now that you want to talk about it, Hank, let's go. Let's go, Hanky Panky. So, here we go. We're going to skip ahead, chattel.
One might have been.
Here we go. There we go.
So I'll take a closer look at both of these and have something later.
Hi, Hella.
All right. So, Ms. Giannetti, I think this next one might have been yours. I could be wrong again. Maybe it's just that you filed some. It's paper 565, defendant's motion eliminate to prohibit testimony regarding funds paid to experts for purposes of voir dire.
That's also mine, Your Honor.
Okay.
I believe the Commonwealth has indicated that they will agree to that.
Okay.
This would age anybody.
All right. So, paper 565, allowed by agreement. So 566, defendant's motion for panel voir dire. Who's arguing that?
That's me, Your Honor.
Okay, so all I need you to really focus on, of course, I'll give attorney conducted voir dire, but why don't you
cool,
focus on
fuck,
panel
right?
voir dire for me?
The request is pretty straightforward. We would maintain a categorical list of topics that is in line with the statute, previous experiences with the criminal legal system, characteristics of the case, including media attention, things of that nature, biases in favor of law enforcement or vice versa, personal beliefs about driving under the influence. We think that's attendant to this particular case in particular, involvement in any relationships involving domestic violence, involvement in motor vehicle crashes, those categorical issues, whether they've ever been victims of violent crime, and their general ability to be fair and impartial in light of Ms. Reed's constitutional rights.
Okay, well, we covered all of that last time as well, right?
And that's exactly right. So we're not asking to change the categorical subject matter. We just believe that a panel voir dire conducted, at least in part, with limitations, obviously, time limitations and subject matter limitations by the attorneys, would be of great assistance to both counsel, both the Commonwealth and the defense, in determining jurors' ability to sit through an extensive trial, a complex trial, and something that's going to be obviously hotly contested. The chemistry between and among jurors is more borne out if there is at least a modicum of panel discussion between and among the jurors and counsel who will be handling the case on behalf of Ms. Reed and on behalf of the Commonwealth. We don't think that there's any prejudice to either side, certainly not to the Commonwealth, certainly not to us. I think all of us would benefit, including the court, would benefit from being able to impanel a fairer and more comprehensive jury.
Okay, it's the Commonwealth's position.
Of course, we defer to the court. However, we prefer a questionnaire. If we have a panel voir dire, there will be quite a bit of contest on the subject areas, the limitations, the parameters. I wouldn't say anticipate, but I worry that it will digress into trying to craft the argument, the direction of argument, in a way that's favorable to each side's cause. And that really isn't the purpose of it, but that seems to happen in the limited times I've engaged in it. And so I think the questionnaire is more structured. It allows for all the different subject areas that are important to both sides. And I may misunderstand, but I think the court allows follow-up on questions where there is any inquiry or concern or a follow-up that's reasonable and necessary. And I understand that that has been a liberal application, and I think that suffices.
The only thing I would say to that, if I may speak from here, the only thing I would say to that is I completely agree. I think a questionnaire is enormously helpful, especially as it pertains to a panel voir dire. And quite frankly, Your Honor, in my experience, and that's what we do where I'm from, is panel voir dire consistently. It's faster.
Okay, I'm just saying, chat. I know you guys brought it up too. This don't work. I don't know what they do in California. Is this the LA thing to do? But man, you gotta have your sideburns connected to the beard. This just, I don't know, man. It looks weird. It looks weird to me. It looks weird to me. So, just saying.
It's actually much more efficient to do a panel voir dire than it is to do an individual voir dire. That's all I'll say.
So I'm a huge proponent of panel voir dire in the right case. My biggest concern here, frankly, if we didn't have the inordinate amount of publicity on this case so close to trial. I heard that there was something last night. It's been in the news, right? And it's continuing. It's because of that. I'm afraid it's just going to blow up the panels. So, and I have a lot of discretion here. I'm not going to allow panel voir dire. I will allow a robust, as I did last time, voir dire at sidebar. We're also on for final trial conference today and tomorrow. So I need a list of witnesses from the defense. I need you to fill out a report so that we know exactly what is still left that we have to deal with. And jury voir dire is a very important part of this. So I expect, as last time, to be able to use a questionnaire. But I want you to agree to it. And if you can't, I need that. I need that by the end of today if you're not going to agree to it. Have you proposed a questionnaire? Have both sides talked about a questionnaire recently?
We haven't, but we do have the advantage. Both sides has the advantage of the one from last year. There may be some adjustments, but I think we're back on to start with.
So let's do that. What Mr. Brennan's new to the case, when I need in a questionnaire is it has to be one page, both sides, no more than one page. At the end of our hearing tomorrow, I would like to talk about the particulars of it. We have a huge amount of jurors coming in. And I have some ideas on how we might best utilize that with the questionnaire, but I need to talk to counsel about that at the end of all these hearings today. All right, but just to be clear, no panel voir dire on this case, unfortunately, I think because of all the publicity. And we'll do extensive voir dire at sidebar and the questionnaire. So 566 then is denied because it's requesting panel voir dire. 567. Defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they've taken the stand. So, is there an objection to that, Mr. Brennan?
There's not. I believe that rule should apply to both sides. I have no objection.
Okay. Mr. Jackson, do you agree it applies to both sides? Ms. Little?
Thank you.
Okay. All right. So that, Mr. Clerk, 567 allowed as to both sides. 570, defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and/or intimidation of witnesses. All right.
Thank you, Your Honor. The first trial, I'll note, was riddled with what we believe to be inadmissible and highly, highly prejudicial testimony from a bunch of witnesses who took the opportunity to describe harassment and distress that they felt from third parties, both on social media and otherwise. No third party, including any blogger, any social media personality, any member of the public, no third party speaks for Ms. Reed. No third party speaks for the defense. No third party acts on behalf of Ms. Reed, is directed by Ms. Reed or the defense, or is under Ms. Reed or the defense's control. None. There were very obviously vile acts that were described during the course of the first trial in these witnesses' testimony. To the extent that they did occur, they are obviously in no way condoned by the defense, by Ms. Reed, or anybody connected with the defense in this case. And they're in no way connected to Ms. Reed or the defense. And notwithstanding that, the witnesses strongly suggested that Ms. Reed and the defense itself were somehow responsible for these alleged and very reprehensible things that they were describing. In one notable instance, Jennifer McCabe recounted being harassed by a blogger. She didn't name the blogger, but she said, quote, "The defense is very familiar with this person," end quote. That was her trial testimony, and she looked right at the jurors when she said it. The very obvious overture was, "You know who this is, Mr. Jackson. I was the one cross-examining her, and you're responsible for it." In some way, shape, form, or fashion, she outright suggested to the jury that Ms. Reed and the defense were responsible for the acts that she went on to describe in great detail, in which we agreed, if they occurred, are vile, reprehensible, unacceptable. There are clearly, as we all know now, there are clearly people out there who are very deeply concerned about what they consider, the others consider, an unjust prosecution of an innocent person for a crime that she did not commit. There is an enormous amount of emotion injected throughout the community, this community and beyond, and we don't control that. And if people have suffered as a result of that, Ms. Reed, very specifically, should not be the one to have to bear that burden, and she did in the first trial. Those individuals out there who are emotional about the case, who are a proponent of one side or the other, they speak for themselves, they act for themselves, they act on their own accord. They certainly don't act at the direction of the defense or of Ms. Reed. And to allow these sort of what ultimately can only be described as salacious anecdotes into evidence, coupled with the sobbing and the crying and the breaking down on the witness stand, which also happened, it serves to visit an extreme and an extraordinary prejudice against Ms. Reed, very, very specifically and very targeted like a laser on her. And it's for conduct that's completely out of her control and completely unassociated with her. What may be most galling about the Commonwealth's presentation of this evidence in the first trial of witness intimidation was that they were in possession. They actually knew. Mr. Lally, Ms. McLaughlin, they knew at the time the information was presented and propounded in front of the jury that a grand jury had been impaneled to hear evidence on whether or not Ms. Reed was in any way liable for witness intimidation, witness harassment, or anything associated with that.
So the grand jury has a particular standard, right? Not any way, right? Probable cause standard,
that.
right? Okay.
But notwithstanding that standard, the question was she in any way liable for that harassment and intimidation? And that standard is extremely low. We all know the ham sandwich anecdote. And even the grand jury said, no, there is absolutely nothing to see here. There's no evidence that she was responsible for intimidation or harassment such that they determined that there was a no bill. And what is bothersome is that the Commonwealth was aware of that and didn't disclose it. We didn't find out about that until in October. I think it was an October notice of discovery when we finally found out that a no bill was issued indicating that Ms. Reed.
When was that no bill issued?
You said when or where?
When?
I want to say March 23rd, March 27th is what I'm being told. It was late March, before the first trial. And they knew this, and they didn't provide what I believe, and I think what the court would have ruled would be exculpatory information to us to cross-examine these witnesses who say, hey, look, I've suffered at the hands of the community, of these bloggers.
So my memory is I kept it out, and then I have a very clear memory of you opening the door with Jennifer McCabe, and it came in through there.
So the court did make that ruling, that ultimately if the door is open, these witnesses are going to be able to talk about it.
But I kept it out prior to that.
Understood.
Okay.
I don't want to revisit that issue. The court made its ruling. I didn't think that we had opened the door. It was whatever that door was. It was on some very, very significant lubricant. It was going to be very easy.
Read the transcript.
I have several times. In any event, I believe that the court should make the exact same order this time and have a more defined, we should have a more defined understanding of what would reasonably open that door. I didn't think that I came anywhere close to it. The court disagreed and the information came in. But it's so prejudicial. It was so extremely prejudicial as to this read that I think we need to revisit that issue and get a more clarifying order about exactly what would be required to open that door. And then we can reasonably, as the defense, we can reasonably sidestep that as best we can. I wasn't able to do that in the first trial because I didn't think that I had even approached the line, but ultimately the court disagreed. So what we're asking in this instance is that we get a clarifying order that it is not admissible. Obviously, if we walk in and say something about witness intimidation, you've never been intimidated by anybody, have you? Obviously, that would open the door. That's not what would happen. That's not what happened last time. What happened last time was Jennifer McCabe basically decided that she wanted to talk about that issue and sort of walked through it, at least in my view, having reviewed the transcript. In any event, I think the court understands what our concern is with regard to the subject matter. We don't want a free-for-all of people, one person after another walking into court and basically lambasting the defense for all intents and purposes about things that are completely out of our control. Even if there is some suffering by the public or by bloggers or by whomever that these witnesses have had to undergo, that is not at the hands of the defense, and we shouldn't have to, Ms. Reed very specifically, should not have to suffer through that testimony when it looks very, very clear that at least the Commonwealth wants the jurors to believe this is all at the hands of Ms. Reed. She's been the one engaging in this, or the defense has, which is just not true. So we would ask for a clarifying order on that issue very specifically.
Mr. Brennan.
I can appreciate the defense wanting to identify the line in which they would open the door to evidence about harassment and abuse of witnesses. I understand why that would be important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me. It wasn't just last night when Attorney Jackson and his colleagues appeared on a documentary where Ms. Reed talked about speaking frequently to Mr. Carney, sharing anything public with him. And you would have to choose to be oblivious to think that that information that is shared was then not generated to intimidate and harass witnesses for 2 years. In fact, Mr. Carney has over a dozen indictments for just that. You've had an opportunity to hear the conversations recorded with Gretchen Voss. You've heard about the tactics used by the defense and the dissemination, not just of public information. So to try to make a public record that is so grossly, not only inept, but fraudulent, I don't understand the purpose of that when the simple question is, what is the threshold of opening a door? We have a motion later this afternoon in another courtroom on this very issue. And I'm not going to go through an entire resuscitation of the evidence or information that I have, because that inevitably would be unfair. But it is unfair to stand up here at this podium and suggest for a second that Ms. McCabe is using a witness box as some type of forum. She didn't drag herself into this case. She was dragged into it.
She 100% did what she wanted to do there.
Stand here and bash witnesses.
Oh, crybaby Hank.
Unsolicited attacks, because it pleases them and fits their narrative. It's something I can't just sit by and listen to.
Oh, you can't sit by.
The Commonwealth.
Your Honor, I can't sit by and listen to this. It's too mean. Oh my God, listen to him. It's like having an uppity and like knowingly arrogant Ned Flanders as your neighbor.
Prosecutors weren't outside patting their bloggers on the butt for a job well done after witnesses were harassed at the family events. That didn't happen. And so if the issue is, what is the threshold when Mr. Jackson opened the door? Well, you can read the transcript. It's very obvious. Open-ended questions, personal attacks, baseless accusations. That opens the door. And it will open the door again, I suspect. Yeah, we'll be prepared. I think the issue is really a trial issue, and an attorney having control of their questions so they don't open the door. That really is the issue.
So do you agree it doesn't come in the Commonwealth's case in chief with these witnesses?
I don't think it ever should have come in the case in chief, and I don't think it would have until I saw the very clear questions that opened that door. I have no intention of raising a collateral issue or trying to present prior bad acts that I haven't sought admissibility for. So I agree. I agree.
Okay.
Your Honor, if I may very briefly.
Sure, just give me 1 second. I want to take one note.
Of
Okay?
course.
That was so weak sauce. It's just like,
All right,
dude,
go ahead.
really, you
I
cried
just
like
wonder
that?
if where this
What a little girl, Hank. What a
ire
little
and these
girl.
invectives from Mr. Brennan come from. He said that I stood up here just a second ago and attacked witnesses and bashed witnesses and made fraudulent statements. Was he listening? I didn't bash a witness. I didn't attack a witness. I didn't make any fraudulent statements. The Commonwealth made their best effort to tether Ms. Reed to Aiden Kearney. And they did it through a grand jury. And those members of the grand jury said, no, it's not true. It didn't happen.
That's not
That's what they said.
true.
At the lowest burden known in criminal justice. So Mr. Brennan can stand up all he wants and say, I saw a TV show and I saw this and I heard an interview, and clearly there's been communication between Ms. Reed and Mr. Kearney. Sure, there may have been communication. That's very different from directing witness intimidation, directing witness harassment for the purposes of undermining a prosecution. That's what they've accused her of, and they failed. And then they kept that from us when they failed and allowed this sort of fabrication of the witness. And I'm not saying that the intimidation that was described on the witness stand was fabricated. That's not at all what I'm saying. Maybe it was true. Maybe it all happened. What was fabricated is that it was connected to Ms. Reed or connected to us. So nobody's up here, Your Honor, and I take issue with Mr. Brennan's tone and tenor. We can all be professional. We can all advocate very zealously and robustly. But let's keep it professional. I didn't stand up here and attack a witness, or what did he say, bash witnesses, use this as an opportunity to bash people. But we could calm the drama down just a little bit and probably get a little further. All we're asking is that it not come in, and I will stipulate and agree with Mr. Brennan that this not come in the Commonwealth's case in chief. And we will be very mindful of what would conceivably open a door to this kind of testimony. And I'll probably seek the court's guidance before I ask a specific question that I think comes anywhere close to that. We'll ask for the court's guidance by coming to sidebar. And I think that could resolve the issue.
Okay. Thank you. I'm going to look at this a little more closely. All right, the next one is paper 571, and the Commonwealth's corresponding is your number 12.
I mean, the biggest problem is, though, when he makes these comments, they've gone on how many, like, you could say this, but you've been on how many interviews? You know, you have been working with Turtle Boy. Like, it's not coordinated, but, like, you guys are on terms with him. It makes it tough for, like, to make these arguments. That's all I'm going to say about that, chat. That's not, like, yes, calling Hank out for being snippy and, you know, a bit, like, you know, toolish, fine, but, you know, don't come out here running like you ain't got no stain on your shirt.
Our paper 586. So the defendant's moving to exclude the serum plasma ethanol concentration, blood ethanol concentration conversion, and corresponding retrograde extrapolation analysis. So who's arguing this for the defense? Because I'm going to ask you whether you want to argue your opposition to it or have the Commonwealth argue make their argument for admission of it. Who's arguing it for the defense?
If you're worried about this being a bad take, I got news for you. I got them all day long. I got all kinds of bad takes in my jacket. All I'm trying to say is the way they did this probably wasn't. I think they could have articulated that a little differently. And why is my printer running? That was weird. Did you print something? Oh, okay. That was weird. All right, we're going to keep going.
Your Honor, I am. And to answer your question, the defense preference would be for the Commonwealth to go first. And we would respond, including with regard to the motion.
Okay. So, Mr. Brennan, our paper 386, your number 12.
Your Honor, paper number 12 seeks to admit the results of the defendant's blood draw at the Good Samaritan Hospital and the resulting serum conversion and retrograde extrapolation. This being a OUI manslaughter and murder case, the statutes that the defense cites don't apply. This is not a simple OUI case. We expect that we will have a witness from the hospital describing the protocol. We will have a witness from the hospital to testify about the blood draw, and we will have an independent, or we'll have an expert to talk about the blood serum conversion. These medical records are admissible. We cited Chapter 233, Section 79 as a business record. I know the defense takes issue with that. However, these records are routinely admissible. Commonwealth vs. Hallinan, 491 Mass, 730, page 736, note 9. Blood alcohol serum conversion and retrograde extrapolation is admissible. While the standards may be different because it happened at a hospital, these are agencies, hospitals are facilities that have standards that comply, that are trustworthy, and this evidence should come in pursuant to those cases in that statute.
All right. Now I'll hear you, Mr. Alessi.
Thank you, Your Honor. Attorney Brennan misstates our position that is clearly set forth in our papers. We are not citing to statutes that discuss.
She's on trial for, she's facing 3 charges though. And this is the thing here. She's got 3 separate charges she's facing for Karen Reed. And that becomes the issue then. You know, the first one is obviously second-degree murder. And that's not correct. She didn't do that. She's charged with vehicular manslaughter. She's also charged with OVI and leaving the scene of an accident where death was caused. Okay? So the OVI is relevant. And the DUI, OVI, whatever you want to call it. There is relevance to it. There is relevance to this whole issue. Sorry guys, why is my camera on? But there is some relevance to it.
Consent of Miss Reed. So I just want to take that because he's conflated issues and not addressed the main issue. Attorney Brennan just said
I agree, he is the best.
The results are reliable. And I appreciate very much that he has raised that, because not only is there no proof that the results are reliable, there's proofs in the first trial admissions as by Mr. Roberts, as well as impliedly by Ms. Knowles, that they're not reliable. And here's why. There is no record evidence as to the method of the hospital determining those levels. Specifically, with regard to the medical records in the chemistry section of those, it says in an annotation, the drug testing, this report is intended for use in clinical monitoring and management of patients. And here's the key statement. It is not intended for use in employment-related drug testing or court-related proceedings. And the issue with regard to the reliability of the testing is it is not stated the basics to go to reliability. Specifically, there's no documentation of how the alcohol test result was obtained, through what procedure, by whom, and the key, what manner of testing. There's 2 ways to do it: gas chromatography and enzymatic testing. And there's a huge difference in the reliability between the 2. There is no record evidence, and it's the Commonwealth's burden of proof to establish reliability. There's no evidence of any of those foundational aspects with regard to the testing. So with regard to those test results, the Commonwealth has to establish the reliability. It is not enough for the attorney for the Commonwealth to simply to stand up and ipsy dixit in saying they're reliable when there is a lack of the information of the factors I just rehearsed with regard to the matter. And another key aspect, which is conceded by the Commonwealth, they concede that the testing did not occur at an accredited laboratory. They concede it. And it's in every single report of the Commonwealth. And we put that in Exhibit A to our motion. For example, it's Exhibit A, the very first page, COM 000994, serum plasma conversion report. It states 2 paragraphs under the chart with an asterisk. The ethanol result used in this serum plasma conversion report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory, and therefore this report does not fall under the laboratory scope of accreditation. Not the words of the defense.
So that's from the State Police Crime Lab, right?
Pardon me?
That's from the State Police Crime Lab, right?
That's correct. And with regard to The next
I don't
document,
recall that happening, but that's good
which
information.
is our Exhibit B. In terms of changing that conclusion in that statement, there is nothing in there to remedy that statement. Exhibit C also mentions, and this is NDAO 296, under background, it's the same statement. The ethanol result used in this retrograde extrapolation report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory. So what we have with regard to the foundation of reliability, we don't know what type of test result this third party did, gas, chromatography, or enzymatic, and we don't know any of the other factors, and it's the burden of the Commonwealth to establish the reliability of that testing. So in conclusion, Your Honor, given that the Commonwealth has not satisfied its burden in this regard, the testing that has been performed is not reliable.
All
It
right.
should be excluded.
Okay. Do you want to respond, Mr. Brennan?
I would suggest the court look to Dr. Fowler's testimony. He testified how blood was taken, how it was preserved, what tests were conducted in the lab at Good Samaritan Hospital, how the lab is accredited. And this is the same issue argued at the first trial, but inevitably Dr. Fowler's testimony is what establishes the foundation for the admissibility.
Okay.
Can I just respond briefly?
Sure.
Thank you, Hunter.
Your Honor has often said that this is a new trial. The Commonwealth for this trial has to establish that foundation. They can't point to the testimony in another trial to establish it. That should have been in their motion in opposition, that they should have put that in, assuming that that is accurate. But it is not in their motion here, and that cannot be relied upon to defend the lack of reliability with regard to those factors. And I will also note that none of the witnesses I just rehearsed, Mr. Roberts nor Ms. Knowles, if we're going to talk about the first trial, ever referenced that as curative of what they said for lack of accreditation. And if we're again going to go back to testimony of the first trial, Mr. Roberts on cross-examination clearly expressed concerns with regard to these foundational absences with regard to testing. Thank you.
Okay.
Guys, and that's a very big thing when you deal with like this. This happens all the time. You get into like a car crash and you kill someone, and you also get life flighted. You go to the hospital too, and they take your blood, and the police try to seize the blood. They try to get a search warrant for it, and they try to yank it when it gets tested. But they're also relying on the hospital test. Some of these hospitals are state-approved labs and follow all the standards and procedures. This is an actual. This is a common issue. As time goes on, more and more of these labs and the process are ironed out. But this is a thing with Karen Reed's case. The cops were sloppy and they didn't do things the right way. You can retrieve a blood sample. They can do things where they put in, Ag, you probably know what it is. There's actually a preservative they could take and they could place in the blood sample. That preserves the blood and keeps it from basically, blood can kind of go rancid if it's not properly controlled. And then they can put it in refrigeration for a bit and get it to an approved laboratory. There's things they could have done, but they didn't rely on any of that. They just relied on the hospital blood test. There's just so many things that weren't done here the right way. And, you know, we're seeing the results of sloppiness here. The state labs bye-bye to your accreditation now. Well, they've had all kinds of problems there. They've had all kinds of problems. But yes, this was a very good argument. And yes, Alessi is the best attorney in the room. By far. So, and here's the thing, chat. Remember, even if you get rid of that count, that's only one of the 3 counts she's facing. So if you get rid of the OVI case, you still have manslaughter and murder. So doesn't, you know, that's not that big of a win. And even if they get rid of this evidence, there's still other evidence to show Karen was intoxicated. Everybody's talking about all the drinking that happened that night. Okay, so that could still be used to show Karen's intoxicated. This is just a beyond, you know, an actual quantification of it. But they can still point out she had a ton of booze. And they can say, look, she's not a very big person, so it probably got to her.
I think we have time for one last motion before we take the morning recess. Paper number 574, defendant's motion eliminate to exclude witnesses' prior criminal history. Who's arguing now for the defense? Is there no objection to this? This is regarding Richard Green.
It doesn't qualify pursuant to the
All
statute.
right, that was my question to you. How do you expect to get it in?
I don't.
Okay. All right, so this motion is allowed. That's 574 is allowed, Mr. Clerk. All right, so what I'll do is I'll seek counsel at sidebar regarding scheduling.
You are muted.
And now she takes a break after the sidebar. Brilliant. Good job, Bev. And now, chat, we're coming up back to the end here. I like how he says a 15-minute recess, but it's like it was a lot longer than 15 minutes. It was over a half hour. So here we go, chat. We're catching back up. And look at this, chat.
So, Mr. Jack,
I told you guys, this is why you got to stick with me, man. We are some time traveling mofos. Check this out. Is that the smoke detector? Bam, bam. No, that is something they have going so people know that it's staying live. Because when they're pointing the camera up at the ceiling, that just makes sure you know that it's live. Shredder says, isn't it the base of the other charges? No, because they're accusing him running him over with the car and killing him. I mean, the manslaughter has nothing to do with the alcohol. The manslaughter is just you ran over somebody in the car and killed him. And it's not murder, but they're also accusing her of murder that she intentionally hit him with the car. So the alcohol isn't the ultimate issue. It just kind of flavors out a little bit more. Why do I hate Karen? Because she was cursed with an awful name. She's got to be a horrible person with a name like that. They should play some on hold music. Yeah. Well, anyways, we're finishing up the last little bit here, you guys. So.
and I'll hear you on that one motion.
Thank you, Your Honor. I appreciate it. It won't take very long. I want to formalize a motion to continue the start of the trial, which is currently set for April 1st. The reason behind the motion to continue is not because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there is a significant appeal that's currently pending before the First Circuit based on Judge Saylor's opinion that was issued about a week ago. Given the complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts. If the First Circuit, and I've been advised by our appellate counsel to bring this up, and it was something that he feels very strongly about, we all do.
Okay, Mr. Weinberg?
Mr. Weinberg, yes,
Okay.
Martin Weinberg. If in fact the First Circuit were to agree with our appeal and were to take some action on count 1 and count 3, for instance, either dismiss it or take some other action and remand down to the trial court for additional action, that would set the trial into upheaval. If once the jury is sworn, jeopardy attaches. And once jeopardy attaches, if there were to be some action taken on count 1 and count 3, for instance, those counts were to be dismissed, we would then be compelled and impelled to move to dismiss the entirety of the trial at that point, because that's a very different defense on count 2 than it is on count 1, 2, and 3. It's a different jury that we would pick. It's a different strategy that we would employ, and jeopardy will have attached and the entire case would go away. Ergo, we believe the best practice for the court would be to continue the trial for purposes of letting the First Circuit make its determination about count 1 and count 3, and that's the reason for the motion.
All right, do you have any timeline on that?
I wish I did. I don't. I do have a generalized understanding of some of the briefing schedule, but in terms of the court making its decision, I don't. So we expect to get our brief in today, probably by the end of the day today. I believe the Commonwealth is going, or I believe that whoever it is that is appearing for the Commonwealth, for the court, I should say, not the Commonwealth, for the court, is due to file their responsive brief, their opposition. I think it's next week. It may be as late as the 26th, I want to say. I'm going by memory, Judge. So it's Monday? Okay. Mr. Schillinger has just indicated, I appreciate that. Did I say your name correctly? Thank you. Just indicated that it's Monday. The opposition is Monday, and then the reply brief would be due 2 days hence. So the briefing is going to be done in relatively short order. The decision, that's another question.
All right, thank you very much. Does it make sense for me to hear from Mr. Schillinger directly, or Or do you want to handle this, Mr. Brennan? Good afternoon. So we do need you to say your name.
Yeah, good morning, Your Honor. Caleb Schillinger.
All right, Mr. Schillinger, I have no idea how this works. So why don't you tell us?
Sure. So as Attorney Jackson mentioned, Your Honor, Judge Saylor issued his decision denying petition for habeas relief last Thursday. The defendant is pursuing a further appeal to the First Circuit. The parties have agreed to an expedited briefing schedule in front of the First Circuit. The defendant filed her brief earlier today in the First Circuit. The respondent's brief is due Monday, the 24th, and then the defendant's reply brief is due Wednesday, the 26th. As Attorney Jackson mentioned, parties are able to control that much in terms of coming up with an expedited briefing schedule. How long it would then take for the appeal to be decided after that is unknown. And the parties don't have the ability, obviously, to dictate that. I think more broadly, Your Honor, in terms of the arguments here, certainly if it were possible to have all of this resolved before moving forward, it would be which charges are going to go forward and which. At the same time, Commonwealth is obviously strongly opposed to moving the trial. And so, while perhaps unfair to Your Honor, if there is some intermediate ground or additional information that Your Honor would be able to provide, I think that that would be helpful. We could further discuss this issue and come back tomorrow. I would note the motion for a stay that they are going to file, they have indicated, or Attorney Weinberg has indicated to me through email, will be filed with Judge Saylor, not with the First Circuit. So there's no deadline that motion be filed today, tomorrow, or even Thursday. So this is not a decision that needs to be made immediately, Your Honor.
Okay.
And frankly, the Commonwealth would benefit from additional time to be able to discuss with the victim's family members, and to the extent perhaps the court is able to indicate whether some amount of time is feasible given the jurors' schedules that are coming in, Your Honor's schedule. That would be helpful information to inform this as well.
All right. I appreciate that. So one of the things that we would discuss at a final pretrial conference is how long this case is expected to take. So I think the Commonwealth filled out the pretrial conference report a few weeks ago and said 20 trial days, 40. How many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth case will be?
I don't remember what I put specifically, but I think if we have full trial days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay. Mr. Jackson?
Your Honor,
24, I'm sorry.
our defense obviously is somewhat
3.5 weeks. I mean, God. Fucking kill us.
dependent upon the Commonwealth's presentation, but
Right.
my best estimate would probably be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury impanelment. Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury. So I'll let both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional months in order to, if we change the date. So that's very problematic. So I'll hear you all tomorrow on this then.
May we address the court at sidebar on one issue before you leave the bench?
Sure.
All right. Well, let's see, chat. What are we doing? Oh my gosh.
Tomorrow, but Thursday morning at 9 o'clock. That'll give you time.
So let's see. I think they come back on Thursday. We might cover this. I don't know. We'll see.
All right, tomorrow, but Thursday morning at 9 o'clock. That'll give you time, Mr. Schillinger, to speak with maybe Mr. Weinberg or counsel.
It will. Thank you, Your Honor.
Okay, so see you Thursday. All right, thank you, everybody.
Okay, so they're not coming back tomorrow morning. They're coming back Thursday morning. All right. All right. Judge Sailor Moon. Yeah, 3.5 weeks of full days. Yes. Oh my God. Just where we're gonna be now, chat. It's where we're gonna be. And it's Chugi Show. We got some super chats we're gonna catch up on here real quick, guys, and other comments. Chugi Show's been a member for 4 months. Thank you for the support. Is saying late and still nothing ever happens o'clock. Yes, all the JFK files got released, and it's like, you know, people are complaining. There's one guy I follow on Twitter, and he's like, everybody's bitching about it. There's no summaries existing. And they were. It was called the Church Commission, and everybody still hates them. So it's like, yeah, I wouldn't want the summaries anyway. I fucking want to read it myself. Oh. Sweet Tooth Fairy is saying, will Karen Reed go away if they say conspiracy? Hi, all. Well, Sweet Tooth, thank you for your support. 23 months. Yeah, I mean, I think there's so many ways they could do this better that will help Karen. I'm just saying what they want to do is not the best idea, in my opinion. I just don't think it's the best idea. There's nothing wrong with saying the police suck, they're incompetent, they may be malicious, everybody hates her, fine. But I wouldn't go any farther than that. You're going to lose if you try to go down the road of it was all a frame job again. I just don't see that working. And I don't see that getting her where she needs to go. There's better things they could do with their time. Brandon for $4.99 saying, "Hello, Clyde. Come sit on Uncle Brandon's lap. I have a tomahawk bone for you." I don't think we're gonna let you dog sit for Clyde anymore. Thank you, Brandon. Robin says, "Is it legal to infest the courthouse with thousands of raccoons accidentally?" Yeah. Nick Ricada said I could loose wildlife into the courthouse. Mel is saying David Yannetti seems to have distanced himself. Anyone else getting that kind of vibe? Well, really, there's two camps. There's Jackson and Little, and then there's Yannetti. And if Jackson and Little kind of shit the bed with all this ARCCA stuff, yeah, I'd be like, you're a consolidated front. You're a front. You're an entire team. And as everything starts falling apart, you're like, I'm gonna scoot over here just a little bit. We're still fighting together, but I'm just gonna scooch all the way over here so I don't take any shrapnel. I don't blame them a little bit there, especially when it's clear they screwed up. Eric Rodriguez is saying, so you're saying Karen should have called Barnes? Yes, always bet on Barnes. Very true, very true. Summonable traps like this is like who do the dicks all over again. Yeah. Is Karen toast? No, but I mean it's gonna be tougher for her as she goes forward here. Breezen is saying excellent timing having stuff out for the Commonwealth now. Yeah, I mean that's the problem. Obviously it's being done in the lead up to the trial for views and everything, but it's like, yeah, they played right into her hands with that. Chinny's saying, how could they get the interview in though? They can do it because they can lay foundation. Like if they let's say Karen admitted to it on the video, they would bring in the people who are there. They'd bring in the producer. They'd probably bring in the reporter. They'd probably bring in the cameraman. Were you there when this happened? Were you running the camera when this happened? Yes. Is this Karen Reed? Yes. Is she here in the courtroom today? Yes. And then eventually they would play in. I mean, but they're not going to, it sounds like, unless Karen takes a stand. So, but there are ways to get that in that are not that hard. Even you could just start with, this is the statement of a party opponent. And if Karen takes a stand, they don't even have to go through all of that. They could just impeach her with a prior inconsistent statement. So, B. Jefferson says, can the network sue on copyright grounds for playing the documentary in court? That would be hilarious. That would be hilarious. Start playing it and then the courtroom gets copy striked. Sweet Tooth Fairy saying, why didn't her lawyers stop her? Because they are, and I think Bob Mata's right, and I think Joshua Sheffer's right as well. They are so wrapped up in trying to exonerate her on top of, they want to win and exonerate her, that they're losing track of, we just need to win. Karen is aged, Katie says. Yeah, you would age, like, this is going to weigh on you. Every day now for the past couple of years, she wakes up probably for a second and then realizes, oh my God, I might go to prison for 20 years. Like, that'll weigh on you. That'll eat you alive. That'll destroy your soul. Pseudosnark says, what do you look for in a prosecutor to know it'll be tough? You don't really know until you're up against them, but a lot of times just if they're well prepared and they know their stuff front to back, but you don't really know until you go up against them. What qualities of prosecutors do you pick up on quick? Like generally if they're on top of things and how well organized they are. But you can also find ones who are, pragmatic, and you try to learn about how they feel, and you try to leverage it and gas them up however you can. Everybody likes a good ass pat, so you always try to like, oh yeah, you number one. And then Johan Naxos gifted 5 subs, and EDW Raptor gifted 10 subs. Chat, they are doing their part to get rid of the Greens. I mean, here they are just doing their thing. Just that beautiful green monster truck crushing those poor little gray cars. Just crushing them up. That's some top quality stuff right there, chat. Some top quality stuff. So thank you guys for your support and your generosity. Justin Hancock says my printer runs faster than me. It does. It does. Matt says, imagine a state full of people with that voice. I know. That's just, it's so scary. So scary. Mr. Massachusetts says, have you seen Severance? No, I have not. I've heard it's good. Deanna's saying, how much do you think Leslie will be involved in the trial? Quite a bit, but I think they're also bringing him on for the appeal purposes. But we'll see. We'll see as time goes. Oh. Brewberry says half those cars are black. Yeah, it's a version of gray. It's all in the perspective. They're charcoal. They're charcoal cars. Axis and striked. No, I'm not going to get striked. We'll be all right. Don't you worry about me. So. Yes, Johan's right. And the Gray Menace. Debbie for $10 saying, were you tracking the judicial decisions today versus the administration? I'd sure like a show talking about the judges are making military decisions, payments regarding the Green New Deals and all that. Yeah, we'll work on that again. We might do another update. Like, we might do a quick show tomorrow about that. There's some other things I think we're going to try to work on tomorrow for Karen Reed. Because, I mean, we're getting ready, Chad. It's coming up on us. So it's the 18th. So within a week and a half, we're going to trial for Karen Reed. And I will warn you now, chat, I apparently am going to have a trial kind of forced upon me with one of my clients' speedy trial issues. Looks like right now it's set for the 15th and 16th. And I'm going to have to be preparing for that pretty hard coming up. So I might be out of action a little bit for Karen Reed. We might just be like, we might end up being a little bit behind on that. Just so you're aware. Just so you're aware. I'm warning you now. But yes, we will focus on that, Debbie. Yes, and thank you for the super chat. Yeah, there's some interesting decisions coming out. The whole issue with the trade Arugula's boys, the Venezuelan gangsters, that's still ongoing too as we speak. And then a skeeve man for £2 sterling. And the brave Scots out there saying this judge has a very calm voice, rather smooth. Yes, it's a very soothing voice. But what she actually uses that voice to articulate is very disconcerting. Emil for $2 is saying, I don't mind an ass pat. Well, you don't know, that's all you then. You can take all the ass pats. Nate says, take as much time as you need. Well, thank you. J-Rock says, I'll sub in for you. Oh. Summonable Trap says it's forced upon me. Well, things have happened and it's kind of getting the courts kind of forcing it to happen. And I'm like, we have time, but they scheduled it when they schedule it. And I'm going to have to ask them if we can, I'm going to have to see what I can do to move things around. So are we going to cover Lori Vallow at all? She's up to, yes. She just had a hearing today or the day before where she completely acted like a lunatic. But yes, Lori Vallow needs to get covered in the lead up. Edit that car to make the more in the truck even more green. Yeah, I might do that. I got to figure something out. Lolita says, never seen that clip. It's completely brand new. That's a new one. That's a new one. Emil says, I played baseball. Yes, Pete Up says Clyde Coit is going to the moon. Yes, off their mind. Yes, very true. Very true. Yes, trendy agua. Yes, there we go. Trendy arugula. There we go. It's so hip and important. So what was the stuff that came out in Kieran Reed is supposed to be very telling? If I make telling but very revealing is this whole like she talked in an interview. Like I get Kieran Reed's not taking the stand now. Like if I was Kieran Reed, she's not taking the stand because if she says stuff like I was pulling glass off John's face, done. She's convicted. So yeah, apparently Kieran Reed's not going to testify now. Good job. Good job, guys. Oh. Moose Nut says watch it. So guys, we'll do Kieran Reed. It'll just be at night. That's all I'm saying. Yes, enjoy a cool, refreshing, trendy agua on your trip to El Salvador. Yes. Yes, the number one drink of people at the CCOT prison is trendy agua. Karen doesn't need to testify, I know, but it sounds like she might have testified. Like they were preparing to have her testify, and it's like, yeah, she shouldn't. She shouldn't. And it's like if they're letting her testify and like if they're letting her give interviews where she's saying shit like this, what else is she saying out there that's really bad? Like they have lost control of their client, and that's a dangerous thing. So, yeah, Karen Reed really said she pulled glass. Yeah, she's like, I pulled like a glass splinter off his nose. And it's like, woo, buddy. Woo, buddy. So, would not be good for, it's not good for Karen in that regard. Oh, I'll figure out a way to make that thing greener. Lolita says, pulled a shard of glass out of your J-Ho face and it bled. She tried then doing CPR. Yeah, okay. Okay, so yeah, I don't know why she, I don't know why I don't know why you admit to, and I don't know why you would admit to any of that. Like that just, especially on camera, man. Jeez. That makes me, when I heard about this, I was like, there's no way she said it. And now I was listening to it. I'm like, wow, she actually said it. And you guys are confirming it. She said it. And it's just like, jeez Louise, buddy, come on. This is a whoa buddy moment, guys. You know, I'm trying to calm down with that stuff. I don't want to gas you guys up. But this is a whoa buddy moment right here. Right here. Let's see here. JRX saying, Alyssa, who did you do the interview with? Investigation Discovery. It's on like HBO Max. It's a miniseries they did. So, the Inside Man says, I don't know how she could know the truth. She told so many lies that night at this point. I left John at the waterfall. I didn't know my tail light was broken. Yeah, she said a lot of inconsistent things. She has said a lot of inconsistent things. A lot of the witnesses in this are very inconsistent. Once again, though, I think the biggest thing the prosecution can't explain is John O'Keefe is laying dead in the snow. How did he die? Like, what was the manner of death? And they don't know the answer to that, and that's going to be reasonable doubt. But yes, all these people are liars. I wouldn't want any of them to be my neighbors. I wouldn't want to be any of their friends. None of them. None of them. Karen Reed was also on the Glare's fundraiser stream. She was? I've never heard of the Glare, but she was on a live stream. Oh, geez. Like, let me see if I could find this. Let me see if I could find this here. Okay. The Glare. All right, let's see here. So there's this. All right, let's see if we can find. Oh my God, Karen Reed really did come on. Oh my. Oh my God, this is a real thing. Okay, this was a real thing. Holy Jesus. Holy Jesus. Yeah. This is Karen's looking desperate now, yeah. Just think their supporters still, you don't show up like this. You still don't show up like this. I don't know. We're gonna have to watch it real quick. We're gonna show this real quick. Here we go, guys. This is the channel. So it's called The Glare. I got Mark Betterow on. Okay. I've talked to Mark once. He's actually a very nice guy. Very nice guy. So let's see here. Let's see what happens.
Up another notch, people. Like, things are about to get really, really heavy right now. So, people, give it up for the one and only
this.
Karen Reed. Wrong sound effect. There we go.
Oh my God, fixing it there.
Oh my God. I can't believe you're here. How are you?
Can you hear me? Good. Can you hear me?
Thanks, J-Rock.
Yes, we can hear you.
Hi, Will. Hi, Mark.
Hello.
Hi,
Love
SC.
it.
Hi. How's
Have
it
you
going,
ever
guys?
appeared on a YouTube channel yet?
No.
This is the first one.
I only
What?
got a YouTube account like a year ago.
That's the only thing about Karen. Why does she has to have like this? The message, like she's got the accent too, and it's like, oh my God! It's like I almost like we need to build like everybody with this accent. I just need to build a wall, and like around the state of Massachusetts and parts of Connecticut, Rhode Island, and you guys can't get out. You guys aren't allowed out.
Okay. Wow, right on. It's so good to see. How you feeling?
Overwhelmed, but not too much more than I felt a year ago, where we were at the same point in time with trial. It's lining up almost exactly. We're like 2 weeks off from start date of last year, which was, I think we started impaneling the jury on April 16th. So we're on the same track. Days are a little longer. Temperatures are a little more palatable. And I just want to say to everyone listening, and the 3 people on this screen that I can see right now, and whoever's listening, that I could not be here with more
Oh, she's going through a dead zone there.
experts, more attorneys fighting at the federal level, which is a whole other obstacle. Without this movement,
Even the phone's like,
yeah, she's in a moving car, but we're getting the gist of what she's saying here. Sorry about that, Karen.
Can you hear me?
Yeah, you're breaking up a little bit only because you're going through an area there, I guess, because you're in your car.
am going to Logan to get Liza.
Okay. Oh, right on. Tell her
So
we
I'm
say
on the
hello
harbor
and we
right
love
now.
her.
Yeah. I will. Why don't I just listen for the next 3 or 4 minutes, and then when you see it light, it means I'm out of the tunnel. And
Okay.
she's in a secret tunnel.
Okay, yeah, let's do that.
I'm running on 2 tracks concurrently, state and federal, and
Yes, and she tried a habeas petition in federal court. It lost. The First Circuit's going to shut her down. So the federal case, the federal is just a waste of time at this point. I don't know why she's wasting resources on that, and I don't understand why.
trial and getting more experts. And I don't know where I said this. I think maybe it was on Ted Daniel, but this is your defense. It's mine, but it's funded by you. You have ownership in this. And we've listened to what everyone has said. We've listened to feedback and tried to weigh it with, what the attorneys believe was the right approach as we retackle this. And it's a concerted effort. I could not afford any of this. I don't know where I'd be. I wouldn't be here right now. So I can't thank everyone enough. I just can't.
Well, I think I could speak for everybody when we say that we truly believe in you, and it is, and I speak for myself personally when I say that I've never been prouder to be part of something like this, because as much as I hate that you're going through this, I'm grateful to you for this, for you fighting like this and inspiring me to want to support you in this way. And I think everybody feels the same way when it comes to that. But no, you're fine. You're fine. I now yeah, and before you go, I just want you to go ahead and tell everybody who your favorite YouTube channel is. We all know who it is already, but make sure to let everybody know for me. Just go
I
ahead.
love them all for different reasons.
Right, the all of them named Clara. Got it. So, but no, thank you for everything you're doing, Karen. Seriously, and you've inspired so many people, and I am so grateful to be able to have your back in all this, because it is the most powerful thing that I've ever been a part of. And as long as you're in this fight, I'm in it. And I think a lot of people feel the same way.
Thank you. I want everyone to know, in addition to the financial support and the donations, I hate going to court. I never want to go back again after this is over, but it's quite the silver lining to pull up in front of the courthouse and see Kurt Maxon's truck and Dina directing traffic and the Sweeneys with Dennis dressed like the judge. I wish I could go and just hang out with everyone and not go in the building, but they all make it as happy an experience. I don't really want to use that word, but it's bittersweet. It's bittersweet, and I feel like this is what I was put on this planet to do, as begrudging as it is for me. But you all couldn't make it. You couldn't.
Oh God, Karen, why would you say that? I was put on this earth to suffer. I was made to suffer. Bob, this is apparently Karen Reed was on a live stream yesterday. For the Glarer. And oh my God. You know, guys, she's made to suffer. She's just like Jesus. God put her here. You know, like, you're gonna get, you're like, you're gonna, my boy, look what they did. Look what these Romans did to my boy. Okay, Karen, not like, you're not gonna suffer like that, but you're gonna suffer. Some guy's gonna make fun of your butthole. Like, suffer, Karen, suffer. Yes, really. Apparently, yes. I think Mark is just sitting here like, he's just like, oh my God, what is going on? He's like, no. Oh, my mom has said that to me a million times. Yes. Oh my God. This shouldn't be used against her. If she takes a stand, this is all coming in. Oh my God, this is just...
Make it any easier if you tried.
Well,
And
I could tell you, for me, it's absolutely effortless. I am proud to be part of this, and I'm grateful to you for inspiring all of us to.
Bob, I don't know who these people. I know who Mark is. I don't know who El Jefe de Verdad is. I don't know who Etsy is. One of our viewers mentioned, one of the people in chat mentioned this channel, so I don't know. Also, this woman Karen Reed, I'm not sure who she is. I've never heard of her before. But no, I don't know who the hell Duck Lips is, and I don't know who this is. This is like a discount what's the name of the guy who's on with Dylan on the alternate juror thing? Who is that guy? Who is that guy? The DEA guy, the DEA cop guy, who's really good. I liked him a lot. That's El Jefe too. I know, but this guy is like a dollar store version of that. So I don't know who these two people are. I don't know. I just don't know. I just don't know.
Right in your corner.
You're in the
and
right
Clever
corner.
was saying hi. Clever was saying hi. I just want to let you know. And there's someone in the chat who hasn't been in here in a long time, and her name is Deets on the Streets. And I would be remiss if I didn't give her credit. She's the person who actually first told me about your case. So, and that was year and a half ago. And and I know that she has been supporting you for a long, long time. So I want to give her a shout out.
Thank you. Thank you. All right. Well, I'll see some of you tomorrow, and I'm fighting to get a fair trial. I was wondering, as I'm listening to you guys in the waiting room, has Brennan tried to exclude literally every one of my expert witnesses?
Well, yeah,
it seems like
I think he's like 12 for 12 right now. So fighting for a fair trial. They're not actually giving me one, but we'll grab it.
They're not. It seems like it's his entire strategy is to cut your legs out from under you.
I think it's the only one he's got. I think it's the only one he's got.
That's my theory, is that he doesn't have a case, so that's his only strategy.
Yeah.
And it's dirty, but we won't get into too much of that. But we'll leave this on a positive note.
Yeah. Thank you all. Thank you, everyone. I'm going to keep watching from behind the scenes here. So thank you so much. Thanks everyone donating and just supporting it in other ways as well.
Thank you so much.
That's what she should have said. Thank you so much for your donations. Thank you for the support. If you guys donate, that allows me to pay for the team who's out here trying to help me. That pays for it. She could have left it at that. She should have had basically a scripted little message on an index card. This whole thing right here. You know, Chad, I do this a lot, but it's just watching her do this.
So much, Karen, for everything you do. We love you, Karen.
Love you guys. See you soon.
Love you.
All right, Karen Reed, everybody. Amazing. Absolutely amazing.
All right, let's see if she came back at all. Who else they bring in? Okay, no. Don't know who these people are. Don't know. Oh, there's Melanie. Okay. Melanie Little shows up. Turtle Boy's there. Okay, so we do know some of the people. And then Gonzo, don't know him. Nurse Kim, don't know him. Don't know Nan Gallagher. Don't know who these people are. Don't know who any of these people are. Okay, so that's the entire thing there. Just like, whoa, buddy. Whoa, buddy. Emily says she doesn't come back. I just wanted to make sure. Yeah, Mark Benero wasn't allowed. Well, he was allowed. He's pro-hocked in for Turtle Boy. It's just he got denied being on the case because of conflict of interest things there. Yeah. Oh, his application got rejected? Oh, okay. Even for Turtle Boy? Huh. Okay. You need to watch the Discovery ID show. Oh, no, I don't need to watch that. But yeah, she's like, I pulled a piece of glass off his nose. Like, why would you say that? Why would you say that? Oh, God. So he got completely, Mark Bedro got boxed out completely out of Boston. It's like, geez. That's not doing much to make me think that Massachusetts is, like, legit. But, like, God. You know, that just makes you just want to, like, you know, if Karen didn't have her attorneys in the car, they're just sitting, well, it's Massachusetts, so you can't just sit there and stare at a pistol muzzle. But you're just like, maybe today, old friend, maybe today. Oh my God, that was just so cringe. Oh yeah, the Karen Reed case. Okay. Blair says, Blair's a lot of pundits who talk about Karen's trials. That's how I found his channel. And there's nothing wrong with here's the thing, guys. I'm not making fun of them because I'm saying I don't know who they are. I don't know who they are. That doesn't mean anything. I'm just looking at it as I don't know who any of these names are. I just don't recognize them. But I mean, he's a bigger channel than me. So that's like all I'm trying to say is I just don't know who these people are. But just the idea of if I was them, really, I mean, like they were just, oh my God, Karen's here. You kind of like, I mean, and none of them are attorneys, but like if I'd have been there, well, Mark is, but Mark should have been like, Karen, you need to shut up. Like, Karen, stop. Karen, slow it down. Slow your roll. Instead, he just let Karen just like right off the cliff. Like Thelma and Louise. It's like, buddy, come on. Just for Karen Shaw, thank you. Does every woman in Massachusetts look like a flail? They have failed plastic surgery. I don't know. Yeah, he's in Pro Hoc for TV. Okay. I'm gonna EFAP all 12 hours. Yeah. Yeah, and I think that the idea that him getting denied because he's on Turtle Boys, I feel like that is a conflict Karen could waive and Turtle Boy could waive. But I think, once again, though, when you do all this, not like when Alan Jackson and these guys screw around and like you have this issue of like where you were kind of playing like you weren't necessarily trying to play games, but the judge thinks you're playing games. Now you need something from Judge Bev. She's not going to grant it. So you're pro bono. You're about to go on trial. Yes. Louis de Smile says not his case, so F it. I'm not gonna lie. If I was involved, like if I was on a thing and somebody's trying to talk, like a couple of years ago now, if you guys have been with me for a while, I was on with a thing where the guy and his wife, they assaulted the lady in the store over masks, over the wearing the clinical mask, and I kept telling them like, you really need to speak to an attorney. You shouldn't be talking, and I wasn't even representing them. It's like, you guys got to do that. You can't, like, if somebody's on a stream like that and you're there, you gotta help protect her. Yeah, you might not be on the team, like officially, but like they wanted you on, and Karen wanted you on, and that person, wanted to hire you. And as you're watching her screw up, you're not going to step in. I don't like that look. I don't like that look. All she said was thank you to her supporters. That was a long time there, Leah. And you talk about like, I was put on this earth to suffer. I was put on this earth to go through this tribulation. It's like, yeah, that's not a good look yet. Did I get married yet? Not yet. 2.0 are going to get married. We have the date already set, and but at some point in the future we will. I'll let you know. Thank you for asking. Are there any professional obligations to try and save the defendant while interviewing him? No, but like, I mean, he really doesn't have a professional obligation. Like, he couldn't be sanctioned for it probably. But I would argue if you're trying to show your street cred as an attorney, that like you'll keep people from stepping on their dick. I think you have an obligation to do that just out of like, you're a professional. You should be helping make sure she doesn't do that. So. They had waived conflict. Bev wasn't convinced that he wouldn't tell tales out of school. Okay, thank you for that, Bob. Were you on with the toe sucker? No, I tried to stop the toe sucker from getting on TV, and he told me to kick rocks. So a little different. So I tried to stop the toe sucker from telling my truth too. Yes. Yes, Karen Jesus Reed. Yes, we're going to get married at Stoney's. Yes, that's the reception. Can we come to the wedding? No. Are we going to live stream it? Yes, like we said, we're going to do the talk to speech. We're going to do the TTS. You could donate. And it's just going to go off randomly in the middle of the ceremony. $50 super chats and higher. Yes, remember that time I was streaming with the guy who was doing coke? Yeah. Yes. So. I'm not getting married at a courthouse, I promise. I thought the defense of Karen were under gag orders. No, Karen's not. Karen has the right to speak. The attorneys are bound by the rules of professional conduct. So I told the toe sucker story when I was on our show. Yeah, and I'll send you guys the clip if we ever come on. You want to talk about it? It's yeah. We're not getting married at a train station. Are you going to serve mediocre chicken parms? It's actually a good idea. I hadn't thought about that. But no, it's Ohio, so it's like you know, you have cheesy potatoes at your wedding. Multiple trays of it in different styles. Oh. So you guys are going to use don't use your word passes. Oh. I don't think I had Clyde on. I don't think I brought Clyde on when I was talking to Bob. But you guys have already heard the toe sucker story. But we'll do more of it coming up here. I need to do it. 50's too little, $100 minimums. Yeah. Are we getting married in an outdoor range? No. Not telling you where it's at. Not telling you where it's at. Who's doing the Billy Wagner trial? I want to do that as it comes up here. I'm looking forward to that. There have been a couple of things, a couple of hearings I want to catch up on. Like I said, guys, I got this trial kind of coming up in the middle of the month that was not preparing for. Well, that the judge is like, hey, guess what you're doing in a month? So I'm going to get ready for that. But yes, we are going to cover that. We're going to cover the hearing where Billy Wagner, the judge, threw the death penalty out because the state had screwed up. So there's a lot to go through there. Billy Wagner is one of the Pike County murderers. If you guys remember, this happened, the family of 8. The Rodens got all murdered in their sleep, and people were like, what happened? And it was all over a custody dispute between all these hillbillies. And they went, the Wagner family went over, the Wagner men went over, the dad and the 2 sons, and they just went to everybody. So, yeah. Will this trial be streamed? No. No. So, Iniaka, Josh, how you doing? Say, Japan weddings are such a scam. Every guest needs to donate 30,000 yen to attend. Well, there you go. Is that really a thing there? Could I have PPP officiate? No, I've got a better officiant than that. We already hired. We've already got a good preacher coming in. We got one coming in from out of town. Yes, the Pike County massacre is the worst ever in Ohio. The hillbillies from Pike County, yeah. So, are we going to exchange Sonichu medallions? No. No. What's the docket number? I'm not going to tell you. Guys, I'm serious. I'm not joking. My clients, they never asked for this. This is not a case that got publicity, so I won't do that to them. Chugi Show saying the wedding cake will look like a locomotive. No. Are we going to let Nick officiate? No. Ethan Ralph, I mean, he'd be an improvement over Nick. But no, we're not going to let Ralph officiate either. I got a different person. And no, it's not Aaron. It's not Aaron. The farms will find out. Well, that's why we're not going to have pictures. So. Will Clyde be in the talks? I mean, maybe. We're gonna have to find one. Hold on, real quick. 2.0. Did you hear that, babe? We need to put Clyde in the talks. Yeah, we can do it. It'll work. It'll work. 2.0 is like, I don't know, and I'm like, are you kidding me? That's gonna be awesome. Nick Ricada said it's okay for me to piss on the wedding cake. Oh, at least a bow tie, of course. Of course. Does Lainey get a bridesmaid's dress? Yeah, we'll set something up. Clyde can walk Sean down the aisle, yeah. Am I getting married in blackface? No. No. Nick wants to stick his dick in your cake. Yeah, well. Johan says, I'm gonna build a wedding venue on that land, bish. Can we at least know the color scheme? I don't think we have one yet. Hold on. Do we have a color scheme? Sweetheart. Sweetheart. Do we have a color scheme? What? Red, blue, and purple with white accents. So. Island saying, look at this chat. I can't imagine why we're not invited. Yes. You need to have your mustache match for the wedding picture. Yeah. So. The colors should be green, only green, Sean. Yes. That's great. We'll use different shades of green. That'll be the right answer. Natasha said, so not blaze orange, no. I'm gonna have a gold AK shooting in the air. That would be funny. Like after we're done getting after the vows and everything, I'll be like, hold on, guys, here. Give everybody a gun. I'm like, now start shooting in the air. We're doing this Yemeni style. Oh. Is Erin in the party? No. So is Karen Dunzo? No, I don't think she's done. I think she's got a decent chance, but it's really going to come down to what is the defense going to make their strategy. Like that Karen Reed was framed, then yeah, she's toast. But if they're just going to say the prosecution's case sucks, well, then they'll have a shot. They still have a shot. Sir Fist says blue and yellow for Ukraine. You know, that's a real great joke. Great joke. Great joke.
You're a funny guy, Sally. I like you. That's why I'm going to kill you last.
That's right. I will kill you last for that joke, but you're a funny guy. You're a funny guy. The table decor is just painted models. Yes. All right. I lied. Dave says, Hank has never lost a murder case. No, I mean, as a defense attorney, that's a hard record to have, but I've heard he's been fairly successful. He defended Whitey Bulger, for example, so. Do you think they'll have a better chance of the explain reasonable doubt? No, I think I don't know if they're going to be allowed to explain it, but they're going to be better off just presenting a different case. So that'll be the biggest thing there. That'll be the biggest thing. Yes, we should go to honeymoon in Granby, Colorado. That would be hilarioso, chat. Muy hilarioso. And Lucas says, hey, man, we're not all that bad, Sean. Okay. Joe Morris is saying, Karen cleans up nice, though. She would have been a smoke show 10 years ago. Probably. I could see that. Demon's Wrath says, first we build the wall, then comes the artillery saturations. Yes. Katie says, going from Maine to Texas was such an accent shock. I can only imagine. And Brewberry's been a member for 13 months is saying, Kazaa, you're facing prison. Is this your calling? A Kaza. Is that what you call her? Kaza. Yeah. Is she trying? And Coffee Bird says she's trying to sabotage her second trial. No. She's just. That was kind of a dumb thing to do, I think. Natasha says, "Is it a dove release followed by doves being shot?" No, because you got to wait till Labor Day for that. So no, I don't want to wait all summer. But that's not a bad idea. Release some doves and just start dropping them. Then you get to have a dove like you eat the doves. You know, when you clean the doves, you clean out the breasts. It's like little chicken nuggets, and you can just, yeah. The wedding cake will look like a locomotive. Thanks, Shugi. I appreciate it. Oh. Katie's saying, I never knew how much we had an accent until moving here. You mean, I thought you're from Ohio, but yes, Maine has a real accent. It's actually kind of an interesting accent. But yeah, even Ohio, like in the Midwest, there's an accent. The Northern Vowel shift that like from Buffalo on down and basically along the Lake Erie shoreline across Indiana and into Chicago. You know, I actually have more in common with people in Chicago than anywhere else as far as the way I speak. So it's very interesting. Have you seen the video release of doves and they're just dead? Yes. Yes. Everyone has an accent. Yes, a little bit, but there's a reason why they use the sterile Midwestern accent for the news. Or try to. So. Long Island is the worst accent. What? Oh, Long Island. Yeah. No, I don't know. The Boston accent's still probably the worst. So, it's a dialect. You're a dialect. But no, the Northern Vowel shift, it's actually one of the biggest changes to the English language since Shakespeare was around. Read up on it. It's actually interesting. So the gay accent's the worst. All right, guys. So we're all set. We're all set here. Yes, it's all dying thanks to TV. Yes. So guys, yeah, there's the Karen Reed saga, and there'll be more to it this week. So yeah, like I said, Chad, I think Karen Reed has a chance, but it depends on how stupid they are with their presentation of facts. So we'll find out. We'll find out. Tomorrow, guys, if we have time, we'll probably do a little split going over Karen Reed stuff and going over some of the motions filed, or some motions tomorrow night. We'll do the motions filed. And if we have time, we're going to do a Trump update too on all this stuff, because there's all kinds of legal stuff that happened today, guys. Debbie says, you're not going to read my second super chat? I thought I did read them both. Oh, Debbie. Okay, I'm sorry. Sorry about that. Thank you for catching me. My apologies. The district court judge quotes the musical Hamilton in justifying her order, forcing the U.S. military to continue enlisting transgender troops. Really? Wow, that's cringe. But yeah, well, I guess we'll take a look at that part too. You know, what comes next? Yes, what comes next? Soon you'll see Trump's gonna defy everyone like me. No, because he's going to defy me like as the judge. The judge is saying, what comes next? Why would he defy gravity? Elon would defy gravity with his rockets. You know. TROs rise. Presidents fall. I don't know. Try to thumb good there. Hamilton sucks. Yeah, well, deal with it. Deal with it. Katie says, I was going to say gravity too. Good job, 2.0. You guys are not helping. You're not helping. Okay? So. I have not seen Hamilton either. I just know of the King George songs. So. She says they're the best songs in the whole thing anyway, so I'm not missing out. Oh, all right, chat. So I will see you guys tomorrow. We got a lot to talk about. So remember, until next time, just because you did it does not mean you're guilty. Like I said, Karen Reed, I don't think they can prove it. But yeah, she is not helping herself here. She is not helping herself. Don't do what she does, chat. Don't do what she does. So good night, you guys. Take care. Oh, hold on here. Why is this not? Come on, there we go. Weapons
blacksmithing and models of planes, esoteric works and even some trains. Much merriment had while drinking White Claws, tips on hunting and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy Rick Hayden yelled at? Why, yes it was. He